where crimes are baked in every show, mysteries rise and truth unfolding. Ready, set, it's time to go. We say it's time to go. Whistling clues, battering news, mixing stories, solving the lies. In this kitchen, secrets are broken with a spark in our eyes. In the broken baker's kitchen, the secrets crumble like sunrise. We'll sift the clues to find the news. With a spark in our eyes, the broken arise. Broken rise. Welcome to the broken baker. Get ready. Let's go.
I'm Jimmy. How y'all doing?
Good morning, everybody. We are starting court a little bit behind this morning, but good morning, everyone. I'm going to jump right into this.
Some of this data, Judge, that I tailored for the court.
But the states is the standard instruction, correct?
Mine's a standard instruction.
Okay, so let's look at the states, and if there's something you would like to add, then please raise that as we get to the appropriate portion of the instruction. So the states, paragraph number 1, any issues?
I think that's the standard there, Judge.
All right. So we're moving on to Laurie Shaver was justified in using or threatening to use deadly force if she reasonably believed that such force or threat, that those 3 paragraphs.
When I put Laurie Shaver, I put in it, Laurie Shaver was, oh, wait a second. Yeah, that Laurie Shaver does not have the burden of proving. That's on there.
That was the first paragraph that we already addressed.
No, that's
Yeah.
one above it.
Yes, well, that is the first paragraph in the document. Laurie Shaver does not have the burden of proving.
Laurie Shaver.
I think they might still have rebuttal. Hello, Jamie. I think they're just doing this first before they bring in the jury.
You see, Judge, well, the states here, right here, it says, if she reasonably believed that such force or threat of force was necessary to prevent imminent death or great bodily harm to herself or another. And it says the imminent commission of an applicable forcible felony against her or another. But it doesn't define at that stage what the applicable forcible felony was against her or another. So that's where I think you gotta insert the required language or what she reasonably believed was the applicable forcible felony for the jury, and that needs to be defined.
All right.
That's why it's set up this way.
I'm going to speed through this a little bit.
Also,
Look at my statement.
Do we need to turn this up?
all right, you listed attempted murder or aggravated battery,
Is
correct?
that better?
You may have to go down further, Judge, where it says threats of forcible felony
Is it better now, Sue?
on the following page.
Yes, I'm there, page 2.
Yes, okay, and that's where I think there's a definition that's provided in it throughout. And the applicable forcible felony was an attempt to murder.
Oops.
or create great bodily harm. And those elements, I think, are specified or should be specified.
Okay, good.
You're asking for the imminent commission of attempted murder.
You listed aggravated battery.
Aggravated battery.
Correct.
Okay.
And those elements be asserted within that self-defense instruction.
There's a place for it.
Okay, that's what the evidence was.
But the previous paragraph of defining every forcible felony, I don't see how that's not the standard. I don't see how that's necessary. We're not dealing with carjacking, aircraft, fire.
That's why I just said an attempted murder or an aggravated battery, and then give those those elements to the evidence. That's it.
All right. Now, the next page, in deciding whether Laurie Shaver was justified in the use or threatened use of deadly force, you must consider the circumstances by which, now that portion, that page,
Hold on a second, Judge. I think you skipped the Laurie Shaver was not committing any crime.
yes, is that acceptable? That's the middle paragraph of the three.
Laurie Shaver was not committing any crime other than the alleged murder.
Okay.
That's correct.
Okay.
Laurie Shaver was not committing any crime.
Okay. But Laurie Shaver was not committing a crime. Yeah, that's standard verbiage.
This part's so
And
boring.
the next one regarding the dwelling.
You know, we have to add in the attempted murder or aggravated battery in the bolded bracket area based on the defense's request.
Correct.
Yes, sir.
Ooh.
Yeah, on that page, we just need to put in, I think where it says defendant, if you want to put in the defendant's name, throughout here and tailor it, take out the himself, herself.
Hold on a second. I left it this way because I initially didn't think that it was relevant to this case.
I can't make that go away. So we're stuck with it.
Judge?
Yes, sir. I see where we're at. And are you objecting to that portion being in?
It just needs to be, the use of deadly force is justifiable if Laurie Shaver reasonably believed that force was necessary to prevent imminent death or great bodily harm to herself or Laurie Shaver.
Judge, we will make this track with the language and the rest of all the brackets.
Okay.
All right, thank you.
And when it talks about the applicable felonies, we will use the same attempted murder aggravated battery that has been requested.
All right.
That brings us to in deciding whether Laurie Shaver was justified.
Okay.
Any issues with that page?
Let's see.
Oh
That's
my.
fine, Judge.
Okay, the entire page is acceptable?
Yes, sir.
All right. Okay,
Yeah.
and the next page. If you find that Laurie Shaver, who because of threats or prior difficulties with Michael Shaver had reasonable grounds to believe, any issues there?
Yes, sir.
All right. Okay, then we're on to 3.6G, justifiable use or threatened use of non-deadly force. Okay, let's discuss page 1.
Well, Your Honor, the state is objecting to that instruction in its entirety.
We've got a lot of jury instructions.
Under
We talked about a proposed instruction I drafted?
yes, your proposed instruction.
maybe we can see
justifiable
Brandy.
use of non-deadly force.
Okay. I thought it says a mandatory lesser under the,
That's not her.
giving her the other statute.
Your Honor, I'm citing to Hossendall, HOSNED, State
Thank you.
128 Southern 3rd 400. Your Honor, this case,
So I guess the jury
others
sits
cited within
on the
it
left.
stand for the proposition that the discharge of a firearm is deadly force as a matter of law. And the discharge of a firearm is the only scenario in which the court should basically only give the justifiable use of deadly force and not extend the justifiable use of non-deadly force. I would direct the court's attention to page 4, the end of although it starts on page 3, goes on to page 4, which is the head notes 3, 4, and 5. On page 4, it goes on to say the discharge of a firearm has been held to be the use of deadly force as a matter of law. In Miller, the court found that firing a firearm in the air, even as a warning shot, constituted as a matter of law the use of deadly force by the defendant. Thus, the trial court did not commit reversible error by not giving the instruction of the use of non-deadly force.
All right, Mr. Wiggs.
Yes, I would say this, we have a separate requirement in the jury instructions proposed by the state that they separately and independently have to find that there was a firearm used. Okay, if there's not a separate finding that a firearm was used, then that becomes a discretionary issue for the jury, and they could conclude that there was non-deadly force. So I think it's appropriate, I think it's mandated right in the instructions themselves.
Actually, the instruction for the justifiable use of deadly force specifically cites to this Hossendall case and says that in those situations, only the justified use of deadly force instruction should be given.
All right, the state's objection is sustained. 3.6G, justifiable use of non-deadly force, will not be given to the jury. Only 3.6F, justifiable use of deadly force.
I am running solo just for the beginning. There will be a Baker sighting a little bit later. He is getting his groinal area massaged.
Is there anything further? We have plea of not guilty, reasonable doubt, and burden of proof. Is that acceptable?
Your Honor, can you give us 1 moment to go back to
I will
deadly
turn the
force?
speed down.
Yes, sir.
The 4 paragraphs from the bottom, if you find that Michael Shaver had a reputation of being violent and dangerous person, there's been no reputation evidence, so that paragraph should be stricken.
No, Judge, we've heard actual
The
physical.
next 2.
No, we've heard testimony, we've seen exhibits offered into trial about consequences and acts of physical violence. So it becomes very, very significant. It's even spoken about by the daughter and the mother that there were acts of physical violence justifying the claim of a belief that there was an attempted murder, and there was a monthly ongoing act of physical violence that was spoken of by the daughter. It's in the standard jury instructions that those specific events be included when warranted. And the statute and the law requires there's got to be some confirmation, some circumstantial confirmation of violence. We introduced the photographs to confirm there had been past acts of violence. There was testimony about the injunctions and the requirement that he leave the residence. So again, the acts of aggravated battery and domestic violence were testified to, and that those specific instructions should be included within the jury instructions and not excluded. They're standard instructions.
There are
Yes, sir.
evidence that he's referring to that he wants to reference as to why that this is permissible use of deadly force is covered in the previous paragraph. If you find at the time of the alleged murder in the second degree, Laurie Shaver knew that Michael Shaver had committed an act of violence, he may consider that fact in determining whether Laurie Shaver reasonably believed it was necessary for her to use or threaten to use deadly force. The 2 paragraphs that I am asking to be stricken specifically go to whether or not reputation evidence was presented. First, reputation of being a violent, dangerous person, and whether or not that was known. And then the 2, reputation of being a violent, dangerous person, they may consider that as far as whether or not he was the initial aggressor. There's been no reputation evidence. There has been acts of other violence, which is covered in the instructions already. I'm just asking for the redaction of the language that deals with evidence that has not been presented.
Judge, in the, there's case law that's in here or sitting on my desk, and it talks about that the family is such a narrow community, you can never establish reputation to offer that specific conduct. So we do have evidence that there were past acts of violence. I'll leave it to the court as to whether you want to just delete the paragraph or you want to put in, again, reference to past acts of violence as demonstrated through witness testimony.
You're saying leaving in the second paragraph stating,
I believe, yeah.
all right, so you have no objection to the reputation being removed.
No, I just think if you want to tailor that, it should have to be tailored to represent that you've heard testimony that there were in fact past acts of a physical nature of violence. Such acts may be considered by you in determining who was the initial aggressor. I think it could be tailored that way because, as I stated, Earhart declares that you can't establish reputation within a home environment.
Sammy spills the tea. Thank you for the $1.99 super chat. That Jimmy clip is gold. Morning, everyone. Yes, it is. It's probably the, the funniest thing to come out of this, besides how funny the timeline seems to be. See, yes, Baker looks way different today because it's not Baker, it's Marissa. Baker will be on a little early or little later. Hopefully he comes back.
He's conceding that there's no reputation evidence, so these 2 reputation paragraphs should be taken out.
No, I'm
And one-
saying they should be tailored to.
And once again, the paragraph that precedes the ones we are talking about, the 2 paragraphs that we precede that we're talking about, if you find that Laurie Shaver, because of the prior difficulties with Michael Shaver, had reasonable grounds to believe that she was in danger, and then 2, if you find at the time of the alleged murder in the second degree, Laurie Shaver knew that Michael Shaver had committed an act of violence, both of those cover what he wants. There's the next 2 deal with the specific presentation of evidence that hasn't been presented, and that's why they should be redacted.
All right, state's request is granted. The 2 paragraphs relating to reputation evidence will be removed.
And Your Honor, the last thing I just want to address on the record before we move on, the way the standard instruction is drafted and presented basically is very much focused on a self-defense claim as opposed to defense of others. And the state realizes that this is what they really are going for, is whether or not Isabel Shaver was aware of these things and acting in defense of others. So I believe that those areas
They need to be included.
where I would say in that if you find that Laurie Shaver, who because of threats or difficulties, I think that we can put for Isabel Shaver in acting in defense of others. And
I made notes on that.
Any objection?
No, I made notes on that as well, and I didn't know what the specific instruction was. I thought the state knew that Isabel was going to say this, and I thought actually they put it in their primary instructions.
So please modify the instruction accordingly.
Yeah, just put in the defense.
I was kind of waiting to hear how the defense would want to handle that, sir. But that's why I brought it up.
Yes, sir. So there's no objection.
And we will work on that. We will make sure we print out prior to any final instructions. Just, we'll address that again and make sure there's no further changes that need to be made later today.
Yes, sir. All right, 3.7, any objections?
Judge, one moment, please.
Yes, sir.
Since we're dealing with the substantive crimes and instructions up to this point, let's say, we had requested instructions on consequentity.
You want to go back to the accessory after the fact? Then?
All right, I have that. Consanguinity as a defense. I've read over it. And the state's position?
He's referring to a statute that has been modified and changed. The statute, the cases that he cites refer to a statute that was modified in 2006. The statute that's currently written, I have copies for. Your Honor, may I approach?
Yes, sir.
That is 777.03.
Thank you.
Paragraph B, any person who maintains or assists the principal before the fact or gives the offender any other aid knowing that the offender had committed the offense of child abuse, neglect of a child, aggravated child abuse, aggravated manslaughter. Apologize. Paragraph C, any person who maintains or assists the principal or an accessory before the fact or gives the offender any other aid knowing that the offense had been committed a crime, and such crime was a capital life, first degree or second degree felony, or had been accessory thereto before the fact with the intent that the offender avoids or escapes detection, arrest, trial, or punishment is an accessory after the fact. The discussion of people being in relation, which is what Mr. Waits is referring to, is in paragraph A, which deals with someone that is a accessory before the fact. So the language that he is requesting is not appropriate, and that's why the standard instruction does not
Sorry.
include any of that.
Any person not standing in the relation of husband or wife, parent or child, grandparent, brother or sister by consanguinity, who maintains and assists before the fact, or gives the offender any aid, knowing that the offender had, which is after the fact, committed a crime, and such crime was third degree, and that's third degree, right? Or had been an accessory there too before the fact with the intent, and the offender who maintains, which I could read this almost.
Your Honor, you can't be an accessory after the fact if you are a relative to a third degree felony.
No, that's fair. Let me read
All right,
it.
please take turns. Mr. Camuccio, anything further? Okay.
No, I think it's still applicable based on the law that I cited to the court, and I don't see where this case has been overturned, Judge, which was Brown v. State, and it states
Brownie.
that Marshall had been charged with a second-degree murder, and Brown was charged with being an accessory after the fact. He first exerts the one guy that there was a relationship of consanguinity as a defense, and that was his defense. The court said, well, you're too remote in the relationship to assert that to a second-degree murder. I don't see where clearly what Mr. Camuccio at the last minute, having produced these weeks and weeks ago, is providing that says that this has otherwise been revoked or overruled. But your Honor, this case provided something with mice type to try to read off of. I read the statute update, I don't see, this is a 2006 version. I've read the latest version of the statute, and I don't see where it changed, as Mr. Camucci was suggesting here.
Your Honor, may I approach?
Yes, sir.
Here's the copy of the statute that was in effect before 2006, which is that Mr. Wiggs cites was the statute at the time. So in 2006, when the Florida legislature changed the statute, the standard jury instructions were changed to comport with the statute, and that's how the cases Brown and Bowen was from 2001, Brown was from 1996, have been abrogated.
I don't believe so, Judge. I'm looking at the current statute, and I don't think that's the position. I think it's still in effect. It's a still viable defense, and we request the instruction.
All right, the request is denied.
He's so insufferable. Yes, I recommend that you definitely go back and watch yesterday afternoon. If you missed it, the daughter Isabel testified. Her timeline was way off. I mean, it's not even plausible unless you have like a teleporter or time machine or something magical. And then Laurie, again, not even plausibly, I don't know. It was terrible. It was absolutely terrible. It's definitely the lighting. It could also be the groin massage that he's currently at. I don't think they'll bring him back on a Saturday for this. I mean, we always think that it's going to be quick because how could they not believe, or how could they not convict her? But we've seen worse.
0.7 plea of not guilty. Acceptable?
If this is just a standard, Judge?
Yes, sir. Okay. 3.9, weighing the evidence. We have to decide yet as to what or if all or any of 6, 7, 8, 9, and 10 will be given.
So this is, let's see where you're looking at.
3.9.
Mine goes from page 3.7 to the self-defense. Okay, 3.9. These are the standard.
Yes, sir, except for 6 through 10. Do the parties want 6?
We had testimony from Adam Narvaez about the reputation for truthfulness as to
God,
Laurie,
it's so hard to
Isabel,
hear.
and Travis. We request that it be included. So,
Your Honor, I don't think we have any evidence of 6.
Correct.
I don't think we have any evidence of 7. We do have.
Judge,
6.
I'd ask that 6 remain in, and I'll tell you what. We did hear from Jeremy Townsend. He's represented by counsel. He has an arguable and viable interest in the case. There may be an inference that he has negotiated some kind of obligation or with the state. He's under compelled testimony of the subpoena, so I ask that remain in.
So it reads, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify?
I think that he could be charged, so there is an interest, so there could be a preferred treatment. That should remain in.
The state's response?
We can leave it in, but there has been absolutely no evidence of any sort of deal. And his arguments that this can be inferred, and he knows that I have a Brady obligation to turn over some sort of deal on that, I think would be an improper argument and completely improper.
I'll tell you what, I worked with the state, I worked with Brad King, I worked with Rick Ridgway, and those gentlemen would infer a preferred treatment with counsel and not put it in writing, and it would be silently implied. So to just say, I don't have anything in writing, there still can be an innuendo that somebody's receiving fair treatment, and to just say, I would do it, and I would turn it over. I'm sure if you had it in writing.
I'm quite frankly offended by the attacks on the character of former State Attorney Brett King and former Chief Assistant State Attorney Rick Ridgway at this point. But what really matters is the fact that I do have a Brady obligation. I would have to turn that over. There is no agreement. There is no preferred treatment. And to just make stuff up and infer it to the jury is improper argument.
And I agree, and I work with those same individuals, Mr. Wiggs.
I worked
Yes.
life cases with them, and that's why they dealt with me.
And the state has a Brady obligation.
Yeah.
And so if there was any type of agreement, you would have knowledge of that. So 6 will be stricken.
I hope not.
Okay, number 7.
I don't think there's been any evidence of any pressure or threat against the witness that affected the truth of the witness's testimony.
Well, how are you going to find that out? How do you know? I mean, the jury, that's a factual determination for the jury.
Well, what evidence has there been, Mr. Wiggs?
I think they can imply something. I think they may infer from their common sense what they heard that there may be.
I've heard no testimony as a state.
That's-
Okay, 7 will be stricken. Number 8, did the witness at some other time make a statement that is inconsistent with the testimony he gave in court?
Yes, there's evidence.
Okay, so 8 will remain. 9, has the witness been convicted of a felony misdemeanor involving dishonesty, false statement? Yes. So Mr. Filmer testified to 3 felony convictions. 10, does the witness have a general reputation for dishonesty or truthfulness?
Yes.
Yes, that remains.
Your Honor, actually what was asked of Mr. Narvaez is, do you know of their reputation? He said yes. He actually never gave a response as to what it was. But if the defense wants that one in there, that's fine.
All right, 10 will remain. So 8, 9, and 10 will remain. 6 and 7 are stricken. Okay, the defendant has testified, so the last 3 paragraphs are applicable.
Listen,
3.9A will be removed, defendant not testifying. 3.9B will remain, defendant statements. 3.10, rules for deliberation appear to be standard. Is there anything further on that?
no, we move on. Okay, 9.
So I think that we all unanimously agree that her timeline was a little off, and I don't know, like she almost had like this nervous tick of like laughing when she was lying. She just kind of laughed at inappropriate times during her testimony. But yeah, I think she's a lying liar who lies, and she was a worse liar than Kayla Montgomery, and that was pretty bad.
3.9B.
Yes, sir. 3.9B will remain. Any modifications?
In the state's packet after 3.9B is when I included the closing arguments section.
I don't
That
know.
In the past,
It's
it's been
tough.
when the cases I've tried to have broken up the 2 sets of instructions before and after closing arguments.
Sure, and I will read the initial instructions prior to closing argument and the remainder after.
Way worse.
So I have the closing argument instruction, both it's standard. Okay, 3.10, rules for deliberation.
These are just standard, Judge, all the way through, correct?
Yes.
All right. 3.11, cautionary instruction.
Yeah, that's standard.
3.12, verdict.
Correct, that's standard.
Okay. 3.12A, single defendant, multiple counts or informations. Okay.
Submitting the case?
Yes, sir. 3.13, submitting case to jury.
Yeah, that's fine, Judge.
And we have the verdict forms. Does everyone have a copy of the proposed verdict form?
We think so.
Proposed instruction I did.
Yes, sir.
Was
We
the
think there'll be a rebuttal.
duty reports. I had submitted a proposed instruction on that. that there was no duty to report a crime just because you had observed a crime. And I attach the authority on that. I think the law is clearly still the same on that issue today.
All right, state's response.
Yes, Your Honor. Let me get that in my. As far as the law that relates to special jury instructions, the defendant must prove, 1, that the special instruction was supported by the evidence, 2, the standard instructions did not adequately cover the theory of defense, 3, the special instruction was a correct statement of the law. That is Wheeler v. State 4 Southern 3rd 599. The court does have wide discretion in deciding whether or not to give or withhold a special instruction. I will say that we have found no case dealing with any sort of special instruction to say that it's not a crime. No one is saying that she is guilty solely by failing to report the crime, so there's no need to instruct the jury as such. It also creates confusion because we are obviously going to argue that the fact that she doesn't report anything, this is a self-defense claim, is a reason to question the veracity and credibility of that statement, and also that we're dealing with consciousness of guilt for the murder itself. So, and there's also the fact that she not only does not report the crime, but lies to law enforcement about the fact that she witnessed this crime, which is part of the accessory after the fact charge. So giving this instruction would be misleading and confusing, and based on the fact that they need to establish that it's necessary and that it's not misleading and confusing, that it should be stricken.
Judge, she's not charged here with lying to law enforcement. That's not the charge. She's not charged with bank fraud. She's not charged with anything other than the charge of murder and accessory. The law still directs that if there's any reasonable evidence to support the proposition of the defense, the court is to grant the proposed instruction.
Probably.
Otherwise, it's an abuse of the discretion of the court. There is, again, the state is thinking that they're going to that the jury's supposed to render a verdict because somebody went on Michael Shaver's account or she made a misstatement to law enforcement. That's not the law. That's not found with any of the instructions that we just went through. So any evidence that she thought that the body had been removed somewhere else, which we've heard that there was evidence that she believed that the body was taken off the site by Mr. Townsend. Somebody called and said there was a trespasser, and the body later shows up there. The defense is entitled to the instruction that the defendant had no duty to report the crime. Specifically, there must be a factual determination by the jury that the defendant committed the crime. So we're entitled to that instruction, and the state's vague statement to the otherwise is not supported.
All right, I'll grant the request. Where would the parties like to have it? When would the parties like to have it read?
Your Honor, should probably go after the self-defense instruction.
All right, is that acceptable, Mr. Wiggs?
Yes, sir.
All right. All right, I will read it after the self-defense instruction. State, please include that. And I think we have the verdict forms remaining. We have count 1 and count 2. Count 1, is it acceptable as drafted? Yes, sir.
I think they might read it here, hopefully.
Yes, sir.
Okay, and so verdict form count 1 is acceptable to the defense. Verdict form count 2 as presented.
Oops.
Judge, I'm going back. Let's go back.
Yes, sir.
Verdict 1. Was the defendant in actual possession of a firearm? I think you need to put the language in there that was used.
They're going through the charge conference right now. And let's see, the charges somebody had asked, I'm hoping somebody here, I think it's second-degree murder, but I don't know, like, the two different counts.
Used in the commission of this crime. She's not guilty of just having a firearm in the house.
Well, no, that's not.
And
So it says, if you checked A, please answer the following questions. So clearly, if the jurors determine that Ms. Shaver is not guilty of second-degree murder, they do not proceed to 1, 2, and 3.
okay,
So as phrased, it is appropriate and properly worded.
okay. You're good.
All right. Then we're on to count 2.
Ah. Thank you.
Oh, no, I understand.
All right. What are we going through here? We're almost caught
That's
up.
fine, Judge, come to.
All right. And I believe that concludes the jury and jury instructions. Is there anything further?
Yes, sir. As it relates to accessory after the fact, and the way the standard instruction and is tailored discusses the fact that the level of the accessory after the fact is tied into the underlying events that they were being an accessory to. That's why I included the accessory after the fact of manslaughter. I suppose I actually need to change that to accessory after the fact to manslaughter with a firearm, and then accessory after the fact to manslaughter on the verdict form. That also does mean I have to include accessory after the fact instructions that refer to the manslaughter instruction. We will add that as lesser included to the accessory after the fact of second-degree murder, and we'll submit those with our final instructions.
All right. And the numbering or lettering on the verdict form as to count 2, there's a D in there. It should be a C.
Yes, sir.
Okay.
Welcome, Mo Raiders.
All right. Anything further?
Nothing, Judge.
Before we call the jury in, let's take a 5-minute comfort break.
Thank you, sir.
All right. Thank you.
Okay, so now we're going to stare at the ceiling for a little bit. Let's see. So now there's, of course, when there's lesser includeds, that tends to make deliberations a little bit longer. If they believe there's any sort of, I don't know, beyond reasonable doubt or something like that, I don't know. It's a tough one because there's no evidence that she did do it. It's really on who you believe. But but the lesser includeds, which I didn't quite catch what they were. Well, accessory after the fact, I think it's ridiculous to believe that she didn't know he was under the concrete slab. That's it's just ridiculous. Her timeline is all messed up. She used his card and his phone. I mean, I don't think the daughter bought Nani lingerie with his card, or sent flowers. She was 7. I don't know. I think she's going to go away, but that's just my opinion. Welcome, low raters. We are just waiting. Let me go live here. We're still staring at the ceiling. So what do we think? What does everybody here think? I can't put up a poll, otherwise I would. But are we thinking that they'll go with a lesser? Oh yeah, she sold all this stuff too. Thank you, Danielle. The selling all these tools and things like
Okay,
that.
are we ready for the jury?
Looks like they're
There's
coming
just
back,
one
but
issue
Yes, sir.
before we bring the jury
absolutely
in.
ridiculous.
I asked Mr. Colicchio who his witnesses would be. It looks like there's a couple witnesses that have been engaging in social media on this cause.
All right.
Okay, if I can approach with this. Thanks.
I do
And
think
what are their names?
Well, Mr.
yeah. I think that yeah, she might skip murder. I also prefer the fan. I also agree with this. I think that she had a better chance of acquittal if neither of them testified, because their timelines were stupid. Her lawyer's stupid. Just my opinion, but I think that hopefully when she, like, if she watched that back, she heard how dumb her story sound, but probably not. I think the only one that wasn't released, I don't know. I didn't catch the end of each person, but I think there was a few subject to recall. Yeah. I hope she came in here and realized how dumb. This is true. This is true. I don't know. It's hard to say with this particular attorney, this defense attorney, because he seems to blindly believe everything she says and gets caught on it. But we know that they can, scream it from the rooftops that and recommend that she does not testify on the stand. But it's really up to the defendant. Oh, I hope your dog's okay. Shore Life Creations. And we just went over the charge conference and all of that. So they're bringing in the jury, and we should be having rebuttal. Yeah. That daughter, it was enraging to watch that. I'm glad it wasn't just, the parents in chat that saw how terrible that was. Like, she was clearly brainwashed or just so messed up from her crazy childhood that she's like, just doesn't know the right from wrong or smart. I don't know. She just not a good liar. She did get testy, and that was not a good look. I don't know. But let's see where we're going to get on bringing in certain witnesses. I'm going to rewind here just.
Philip said his wife doesn't go by.
Do you want the sidebar to go on, or do you want?
Oh, I don't care.
Okay.
I want to do it here. That's okay.
All right.
Oh, thank
There's,
God. No sidebar.
This Philma, right, she goes on social media by Philma. Okay? And to make that abundantly clear reading and intention. Okay, using the name Thelma. Miss McManus, she's on the internet as well.
Her first name?
Rena, MarNHINA. Karen, they're both present. You can inquire on that and watch that.
I can't really understand this, so hopefully
Here's the timeline set
All
forth.
right.
That was out.
hopefully the closed captioning are catching some of this. Zach, thank you for the $4.99 super chat, and thankful that I read ahead. All I know is you should never trust a Florida girl with dyed hair and tats. Oh, hi Danielle. Zach, thanks for the super chat. I'll be sure to make sure that Baker gets that one. Let's see. And again, I can't really hear these what they're saying so much, so we'll rely on the closed captioning.
That's from, right after the pre-trial. And here is, Miss McManus is 2 hours from the date on that.
Would you like to bring that into the building?
Yes, sir. Let's do that.
Can you get Rena first, please?
Please come up to the witness stand. Good morning. All right, please be seated and let me know when you're ready to proceed. Okay, please state and spell your full legal name.
Rena McManus.
Okay.
Rena is RHINA, McManus, McManus.
Thank you. Please raise your right hand. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. And
I believe that she was released. But they're bringing her back and they're going to get into it now.
have you yesterday or during this week viewed any broadcasts of the trial?
No.
Okay.
Only like during the weekend when they were picking the jurors on the news, but nothing.
So only over the weekend. Okay. But no picking or selecting of jurors occurred over the weekend. That began on Monday morning. Okay. But so you did view some broadcasts regarding the case prior to trial.
Just listening to that they were going to pick and this was going to happen, but that's it.
Okay. And did you go on social media and post anything concerning the case?
No, sir.
Okay. Did you view anything about the case on social media?
No, sir.
All right. Does the state wish to inquire?
Mrs. McManus, anything that you have seen at this point, would that be news reports about the case?
Not news reports, just like I'm sorry. Just stating news over like Channel 9, stating that like there was a trial going to begin, and that's it.
There has been
Shout out
live
Channel
stream of testimony from this case on Court TV and maybe other sources. Have you watched the testimony of any of the witnesses that have testified this week?
No, sir.
Mr. Wiggs?
Yeah, the rule of sequestration was invoked at the pretrial, and the evidence we submitted to the court shows that she has been engaged looking at and discussing the matter with other people on the internet. We believe that is a violation of the rule of sequestration.
Do you have that document? Show that document to the witness, if you would, Mr. Wiggs. It's up here.
She is being called in as a rebuttal witness. It sounds like they're trying to, and the defense is going to try to keep her out because obviously she's a state witness, but And yes, Rita McManus, I think she said, something McManus. I'm not sure how she comes in, but we'll see.
You may approach.
Me too.
McManus?
Yes, sir.
This shows communication on a date specific at the top of this and communications transpiring, correct? Your name is on that document,
Down here, sir?
correct?
Yes.
Okay, and there's discussions about the case on a particular date referenced from this communique, correct? So while this court case was open, the rule
Look
had
at her
been
face.
invoked. There was to be no discussions by any witnesses and no review of social media. When did you look at this?
I did not, sir, but
Okay.
my,
Let me ask, why does it
Yes.
have your name on
because my daughter and my husband, they all use my phone.
it? Okay,
But I did not, because I got an email from somebody from the state attorney saying not to look at that. And that was, I think, on Tuesday or Wednesday,
Okay.
something like that.
And you have abided by that request, correct?
Yes, sir.
Okay. All right.
I think that's sufficient, Judge. The state wants us to assume just because there's an internet browser in this household, nobody else had access to it, and nobody else could internet it or enter that same site. That's the inference they want to inform the jury about. I'm not satisfied. I'd ask that Ms. McManus be excluded.
All right. Anything further from the state?
Can we excuse, is there going to be any more inquiry of Ms. McManus? Should be excused?
State have any inquiry?
Let me ask.
I have no more. I do have cases in the rule. I'm just, if
Oh,
Ms.
my.
McManus can go back outside.
Mr. Wiggs asked for.
Did you see Mr. Wiggs? Did you see Mr. Wiggs' face? Oh, I need to go back because it was worth it. He just no love lost between these two. And she looks like she's just staring blankly into, I don't know, oblivion probably. And you're right. If Jess is here, she's definitely going to explode. Anyway, just check out that face.
I do have cases in the rule. I'm just, if Ms. McManus can go back outside.
Mr. Wiggs asked for a minute to
One moment.
review documents. He may have some additional questions.
Jackson has a better stare. I have to say that. I mean, you'd think if it was damning, it would have been brought in sooner. Plausible. I think you can right click on her and unhide or use the little 3 dots. They muted us, so just so everybody knows. Let me, oh, because he's talking to her. Oh, I see Danny back, so it looks like you fixed her. Wait, that was the wrong one. Yeah.
Wednesday, 11:55 this week, correct?
11:55. I don't know. I do have my phone and I can.
Okay. My client has her phone record showing that. Judge, I don't, but we know it's during this week time. That's when we found it and discovered it. She's acknowledged that people within the household, she declares, were using her phone. I'm not satisfied with that.
It's not nice, Baker.
Yes. And my client has her phone records.
All right, and Ms. McManus has testified under oath that it was not her, but a family member.
Right, that doesn't seem to jive with the state when my client testifies to those same facts, Judge.
He's got a
Is there any
point.
more inquiry from Ms. Miller?
Anything further, Mr. Wiggs?
No, thank you.
You may step down from the witness stand. Thank you.
Your Honor, I do
Please
have
remain outside the courtroom.
the Florida statute 90.616, which deals with rule of sequestration, along with Hines v. State 719 Southern 2nd 358. Provide those to the defense and the court. The rule of sequestration only extends to the viewing of testimony. Watching news reports or anything like that is not contemplated by the rule of sequestration. And in Hines, the court points out that the appellant correctly, this is from Head Notes 1 and 2, appellant correctly argues that the trial court erred when it applied the sequestration rule as a strict rule. A trial court must first determine whether the testimony of a witness would be substantially different after having heard the testimony of other witnesses in violation of the rule. Should determine whether the violation was intentional or inadvertent, and if intentional, whether it was the witness, party, or attorney who acted in bad faith. Once it has been determined that the circumstances surrounding the violation, the trial court may then exercise its discretion in deciding whether or not exclusion of the witness is necessary. In this case, the testimony of Rena McManus, she is the teacher of Isabel Shaver during the calendar year in question.
That's
and
a
she's just
teacher?
going to testify about the child's demeanor. And
Good
there was
grief.
never any period of time where there was any sort of change.
Did you all hear that? I'm appalled. That woman did not look okay, let alone okay enough to be a teacher. Holy crap. She's Pete's. Yes. Baker is he's getting his injury fixed-ish. I mean, fair, but she did not look well. Do you look like you're on some kind of, prescription that is not prescribed to you when you are teaching children? I hope she's not still a teacher. Good God. Fair, but damn, she looks like a Lake County school bus driver, which is even more scary. Wow. And also, side note, and this is like not anything against the Florida women, but is it the humidity that makes their hair that way? Or is it just like they want their hair to be that big? Because I had that like poof bang thing going on in probably 1996. I hope so. I mean, thank you. Rita McManus. Yeah, I'm thinking like it's a 90s thing. They're just, the 90s didn't go away. Maybe it's not just Florida. I don't know.
And also I have the school records of Isabel showing her attendance, her grades, things of that nature. So there's no evidence that she has actually viewed any testimony in this case. Whether or not she or someone in her family liked a post about the case does not warrant exclusion in this case.
All right, Mr. Wiggs.
To the court, Judge, the data, the information she's looking at is court TV. It's not just a little blog from one person to another. The heading directs that she's observing this. But that she's observing the trial matter as it's proceeding. It's not just a little blog from one person to the other. So I believe the witness has violated the rule, then she should be excluded.
The motion to exclude is denied. As to Ms. McManus, now we're on to Ms. Urbanowski.
So yeah, it sounds like I'm having trouble hearing myself. I'm not sure if you guys are able to hear very well, but and yes, Laurie is definitely having a conniption over here, and she is on her phone, probably. Yeah, it looks like she's on her phone right now, probably looking at Facebook and finding something that, whatever. But I don't know. It sounds like this woman is coming in. I don't think the judge cares that she liked a post. And we'll move on. Denied. I like that. So, yeah. So regarding the hair, I'm not one to talk today. I did not put any product in my hair, and it's kind of crazy because it's humid out today, which I get. But Danielle, if I were you, if I lived in the same county as that woman who's a teacher, I would probably move anyway. Not to mention the dinosaurs in all of your lakes. Hey, Tom.
Good morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed.
Now we have a different witness. I think our only chance was to have a jury at this point. Juries are juries.
Are you all set? Okay. Please state and spell your full legal name.
She has good
My
hair.
name is Rebecca Urbanowski. It's Rebekah. Last name is Urbanowski.
And please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Please proceed.
Ms. Urbanowski, have you viewed online any of the testimony of any witnesses in this case?
No, sir.
Did you have a Facebook profile?
Yes. A business and a personal. Yeah.
And there was a reference, I believe it might have been like on a 4TV post with your Facebook profile liking the post. How did that come to be?
I'm not sure. I scroll pretty fast when I'm going through Facebook, and a lot of the news channels were covering this. If I might have hit that, then that's my fault. I don't know, but
Even if you were to like posts such as that nature, that doesn't necessarily mean you viewed the video on it, correct?
correct. No, I did not.
Have you viewed any of the testimony in this case?
No, sir.
Nothing further, Judge.
All right, Mr. Wiggs.
Have you been looking at court TV?
I've seen some, not this week. I've seen some, not this week.
That's your name, Rebecca Filmer?
Yeah, it's me.
Okay. And Rebecca Filmer on this one, correct?
Yeah, it's me.
And that says court TV up there, correct?
Yeah, that says Court TV.
Okay. You go by Urbanowski?
That's my legal name, but I go by Filmer.
Okay. Yeah, we heard different from your husband this week. But this would have been Wednesday, 4:37 this week.
Okay,
Is that correct?
if that's what it says.
Is that correct? You think?
You
don't know. Okay. Judge, we'd ask these be admitted into evidence,
It's fine.
and because of the questionable nature,
Well, as far as the hearing, that is fine.
All right.
because, yeah, correct.
So admitted into evidence as to the hearing only, not as to the trial. And what exhibit are we up to?
I think this would be exhibit 1 for purposes of the
Purpose of the hearing, it'll be a composite of 3 documents. It'll be Defense Exhibit A. It'll be entered into evidence without objection as defense number 1 for the purposes of this hearing only.
I don't have any further questions. Just
Oh, that's Rebecca Austin's wife. Is that a full name or should there be a comma? Oh, that's Rebecca, comma, Austin's wife. Also, yes, these people need to stop watching the trial. And yes, these are rebuttal witnesses. They are pulling them in to, I guess, do a proffer and asking them if they read anything, saw anything, watched anything. They're not jurors, but they still should be sequestered, apparently, according to some paper that came out. Comma, okay. Got it.
All right, and please proceed. Yeah, further questions? Okay. All right, you may step down from the witness stand. Please remain on standby outside of the courtroom. Thank you. All right, proceed with argument, Mr. Wiggs.
because of the sensitive nature of the case and the clear instructions of the court to every juror and the obligation of the state, and this matter has proceeded more than once throughout the trial, the state has had ample opportunity to properly advise the witnesses not to be talking. I know the court repeatedly questions the jurors whether or not they should look at, that they don't look at anything. This woman was not responsive and not definitive as to those questions. Yet we have physical evidence that's now in evidence that she has been viewing objects. We ask that she be excluded from this cause.
All right, state's position.
She gave definitive evidence that she has not actually viewed any testimony of the case. That is what would invoke the rule of sequestration and the inquiry. And there has been absolutely no testimony about how that would have impacted or altered her testimony in any way, even if it had been viewed. So therefore, the request should be denied.
Motion to exclude is denied. Is there anything further before we call the jurors
Denied.
back in?
No, Your Honor, not from the defense.
State?
No, sir.
All right, let's bring the jury in. Thank you.
The looks Wiggs gives the state anytime he talks about it, it's like with absolute disgust. Like, I love his looks. I wish we could see like the front of them as they're talking rather than the backs of their heads. Yes. This guy with the
All right, please be seated.
half hair thing.
I see that all of the members of the jury have returned. Thank you again, members of the jury, for your time, attention, and patience today. And I have a few questions for you before we begin. Did any of you speak with anyone or each other about the case? Okay, everyone has answered no. Did any of you view any media, news reports on the internet, anything about the case? Okay, everyone has answered no. Did any of you conduct any research concerning the case? All right, all jurors have answered no. Did any of you encounter or speak with any of the attorneys who are present in this case? Okay, all of the jurors have answered no. Anything further from the defense or the state? All right, then the defense has.
I think it is late stage male pattern baldness. Let's try to. I'll try to be politically correct, but and Danielle, this pop-up thing keeps coming up on me. Go away. I'm not sure if Danielle saw Baker's request, but if you'd like to come on later, let us know. And yes, I bet Laurie is big mad, and good. Just my opinion. Kind of glad.
Arrested. State, you may proceed.
State calls Rena McManus.
Rena or Rita? I'm trying not to piss everybody off. Thank
Good
you.
morning. Please come up to the witness stand.
Toy Marissa Rocks Fun, Grancy for covering for Baker. Thank you very much. I'll be sure that Baker gets this.
Be seated, make yourself comfortable, and let me know when you're ready to proceed. Okay, please state and spell your full legal name.
Rena McManus, RHINA MCMANUS.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Please proceed.
Can you please introduce yourself to the jury?
Hi, my name is Rena McManus.
Do you know Isabel Shaver?
Yes, I do.
How do you know her?
She was my student at Pine Ridge Elementary.
And what year was she in your class?
She was in my class in 2016.
Would that be the school year then going from 2015 into 2016?
Yes, it is.
Now, what grade did you teach then?
First grade.
How
Schonberg,
old were
no.
students in first grade generally?
Generally 6 or 7 years old.
And did you know Laurie Shaver?
Yes.
And what about her father, Michael Shaver?
Yes.
And how did you know them?
I had met, they were parents of Isabella, obviously, but I had met them both, meet the teacher, that school year.
And both Michael Shaver and Laurie Shaver attended that event?
For meet the teacher, yes.
And how were they acting during that time?
Normal parents, inquisitive about how the year would be, wanted to find out about me and the curriculum. It was very pleasant.
Now, over the school year that and you were dealing with Isabel Shaver, she had good attendance,
Yes.
good grades,
Yes.
and did you ever notice any issues with her?
No.
Was there any time that you saw some sort of behavior change in her?
Not at all.
Any time where she appeared to become more withdrawn or acted in a different way?
No.
Could I go ahead and at this time admit the records, school records of the children, showing defense states MMM for identification. The state moves into evidence, states MMM as the next numbered exhibit, as a business record with the proper business record certification and notice.
I believe we're up to 65, correct? Okay, thank you. Any objection?
Judge, no objection.
Without objection, states MMM will be admitted into evidence.
Toy, thank you for the super chat. Distracted one. I should be getting ready, but yeah, I probably should be working, but here I am. Thank you. Not incredibly much. You really haven't missed much. This morning we went over the charge conference. There's lesser charges included, of course, so I'm sure Laurie is going to be convicted of something, thank God. And then it's really just a matter of how long she's going to go away. I hope I didn't just jinx it. And then we went through 2 witnesses about being on social media and they were supposed to be sequestered or something, but the judge didn't care. And The most absurd moment of this trial when Laurie discussed being in witness protection. Yeah, like that's not something that they can look up or something. Yes, I think that's why this teacher is on. Didn't mom say yesterday she took daughter to school after it happened? And the daughter said that too. So, and her reasoning for that was she didn't have anywhere else to take them, I think. But I think she's blaming her daughter and her ex-boyfriend, Jeremy. I don't know. I think maybe the plan is to confuse the hell out of everybody to have some kind of plausible deniability. I don't know. Good morning, Ralphie. Yes, it was. She was at Pine Ridge Elementary, and her name is Rena, Rhina McManus.
That's states number 65.
And I'm showing witness red number 1205 on the bottom. You recognize these as the records for Miss Shaver while she was in your class.
Yes.
And does that confirm everything you've been saying about attendance, grades, behavior problems, things of that?
Not at all. Yes, it does.
Throughout your teaching experience, you encourage students to talk to you if they have any sort of problems.
Yes, of course.
And did she ever talk to you about any issues that she had at home?
Never.
Did you also teach her brother Aiden?
Yes.
And when was that?
2 years later.
And how was his behavior when you were teaching him?
Just like hers. Sweet.
Nothing further, Judge.
All right, thank you. Mr. Wiggs?
How old was this about?
7.
7 going on 8?
I'm not 100% particular about her birthday.
Correct. Okay. What degree do you hold?
I have a master's in education,
Anything else?
my teaching degree.
Okay. You have a degree in psychology?
No, sir.
Okay. How large is your class?
Usually from 17 to 20.
Okay. So you're here talking about the mindset of Isabel Shaver, correct?
Well, I'm talking about not her mindset, but the behavior that I witnessed.
Right. Okay. And your mind may reflect your behavior to a sense, correct?
Correct.
Okay. Your behavior actually may be shielded by other events in your life, correct?
My behavior?
No, anybody's.
Oh, yes.
Okay. They may want to lock up. They may want to be quiet, correct? Isabel was relatively quiet, was she not?
Yes.
Okay. Do you hold any degree in psychology?
No, sir, I don't.
Any degree in sociology?
No, sir, I don't.
Okay. How large is your class?
It goes from like 16 to 20 students.
How many sit downs did you have with Isabel Shaver on a one-on-one?
Many.
Any?
Mostly, it's all academic, so we do small groups. So,
No, I'm not talking about a small group. I'm talking about you on one-on-one with Isabel Shaver.
in what manner, sir?
I'm just asking you, did you have any one-on-one sit downs with Isabel Shaver?
In processing education, the way we teach, yes, sir, I did.
You sat with Isabel Shaver individually without anybody else around.
That's not what I'm understanding.
I don't know.
So I have
What?
never.
No, ma'am. Let me ask you.
Objection.
Please allow the witness to finish answering. You may finish your answer.
Sitting on a one-on-one in a room isolated, that's not what we do.
Correct. I don't care about what you do. I'm just bringing that point out. You didn't do that.
I think you should care about what I do because I'm a teacher.
Ma'am, I'm bringing out a point.
Okay, sir.
You're not sitting there with Isabel Shaver doing any kind of psychological analysis.
No, sir, that's not my job.
Okay. You don't have a degree to do that, correct?
No, sir, and I would not.
Correct.
But she can notice her changing
sir.
behavior.
Yeah.
It's such a stupid argument because she works with kids.
Right.
She's the main person that are in the kid's life next to the parents. She could notice a change in behavior. Sorry.
Yeah. It's ridiculous.
Mr. McManus, would you have individual conversations with all of your students throughout the course of a year, although other students may have been present in the room?
Yes.
Nothing further, Judge.
Thanks. We have no further questions.
Should be released from our subpoena.
Yes, sir.
All right. Thank you for appearing today. You're released from further testimony. Have a good day.
The seat calls Jared Strickland.
That's the one with the speech impediment.
LAND. Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Please proceed.
At this point, I'm pretty sure the jury knows you, but can you reintroduce yourself?
Sure. Corporal Jared Strickland, the Lake County Sheriff's Office.
We've been having various discussions about Facebook profiles. The last section I want to cover with you did you view various pictures of Laurie Shaver's child, Isabel Shaver, from November of 2015 through May of 2016 on Laurie Shaver's Facebook?
Yes, I did.
Showing defense was previously been marked for identification as states NNN.
Yes.
Showing the witness was previously been marked for identification as states NNN. Do you recognize those photos?
Yes, I do.
And are those photos from the Laurie Shaver Facebook profile?
Yes, they are.
Or at this time, the state moved NNN into evidence as the next number to be set.
All right, that would be 66. Any objections?
Yes, Judge, the standing objection as to the motion regarding digital data and the relevance issues we've raised previously.
All right. The objection is overruled. State NN will be admitted into evidence as states number 66.
And Detective, it's easier to just reference the posts from the pack I gave you. Go ahead and publish. Good for you guys. So this first photograph that we are looking at, when was that posted?
November 18th. Actually, November 7th, 16th, 2015.
So approximately 6 days, approximately a week after the last known sighting of Michael Shaver.
Correct.
Moving on to the next post. When was this photograph posted?
November 21st, 2015.
We have a series of I believe this is about 6 photos. When were these posted?
Are these the pictures with the cookies?
Yes.
Hi, Marissa.
November 22nd, 2015.
And that will extend on to the picture that appears to have a gummy worm coming out of her mouth, out of her nose.
I don't know if I'm in order. I see the screen.
Yes. This photo here is part of that same April post, correct?
Yep, there it is. I believe that those are, or the dates are out of whack. It looks like the end of March 2016.
And then the photos here, first of all, this post that starts with page 1828 goes on to the photo 1829. Do you have a date for the post? Actually, I believe it goes over to when were these photos posted?
May 3rd, 2016.
Finally, picture of her in the black dress, the post that went along with that. When was that posted?
May 19th, 2016.
Going back to the excavation of the Shaver residence, were you involved with contacting Ms. Shaver after the warrant had been completed?
Yes, I was.
And how did you contact her?
Back home.
So she was not in any sort of custody.
That's correct. She was not.
And when you were calling her, what was the purpose of that call?
To let her know that we were finished with the search warrant and that she could return to the house, and also to let her know the items that we had taken.
And at that time, were you asking her any questions, or were you just informing her of those facts?
Just informing her of those facts.
Showing the defense what has been previously been marked as states AAA for identification. Showing the witness, states AAA. You recognize that?
Yes, I do.
And what is it?
This is a CD copy of the phone call that I made to Ms. Shaver.
How do you recognize that?
It has my initials on it.
And have you reviewed it and listened to it before initialing that?
Yes.
Is that a fair and accurate reporting of that conversation?
Yes, it is.
At this time, the state who states AAA into evidence is next numbered exhibit.
Is there any objection?
No objection. Please just object irrelevant.
Objection is overruled. States AAA will be admitted into evidence as states number 67.
You're going to ask to publish.
Permission granted.
Thank you, Jessica. But there's so many great creators out there. You should give some of them a try. Move it along. Bum, 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 bum. The girl for me, Penina. As soon as Marissa leaves, everything breaks down. But I like that she again tried to prove someone was on social media and it got thrown out, because why are you on social media trying to find people? You are in the middle of a big case. Maybe do that. She's out on bond. I believe she has custody of her kids.
Hey, hey, is Laurie happen to be with you by chance? She is. Is there any way I can help her with it? Yeah, let me see what she's doing. This is Laurie. Hey, Laurie Shaver Firepit with the Sheriff's Office. Hi. I just wanted to call you up for review of the property that we are done out here. You guys are welcome to come back anytime. Okay. We locked the doors back up. Put the keys all settled down in the shed back where it belongs, and everything is in order. But I do have to real quick, and further paperwork will be left in the house. Okay. To include all the items that we took. If you have to, I would like to just run over the list of items real quick with you over the phone and let you know the items that we took. Okay, absolutely. Okay. Total wireless cell phone, swab, micro SD card,
What's swab? What's swab?
most of the swabs are going to be stuff that, like,
Swab, things that you swabbed. Okay, gotcha.
flash drive, a photograph, miscellaneous paperwork, a HP laptop, additional swabs, SD cards with photos belonging to Lloyd County Sheriff's Office, possible buckshot TVs, projectiles, unfortunately this is a word that I cannot read, and human skeletal remains. So as far as all that stuff goes, do you have any questions?
Yeah.
Okay.
Right.
I heard they had taken a flash drive and a picture and some swaps. That's what I got out of it.
During this phone call, did you inform Ms. Shaver there was human skeletal remains found on the property?
I did.
Did she react in any way?
No, she just said okay.
There was some mention of a computer, some SD cards, things of that nature. Were those ultimately reviewed to see if there was anything relevant about the time frame of this homicide?
Yes, they were.
And was there anything relevant on those various electronic items that were?
There were not.
Nothing further, Judge.
Mr. Wiggs, just a minute, please, report. May it please the court.
Yes, sir. Please proceed.
Deputy,
Corporal.
Corporal, sorry. You were quite polite on that call, correct?
Excuse me, I can't hear you.
I believe you were quite polite on that phone call, don't you?
Yes, sir, I do.
I believe that Laurie Shaver was quite polite on that phone call, don't you?
Of course.
And I don't believe we heard any confession of a crime or any implication of any guilt on that phone call, do we?
To repeat what I've tried to say for the last 2 days.
No, sir.
Whenever you take
No,
all
sir.
of the evidence as a whole.
Sir, please answer the question directly.
As to this phone call, do we hear any confession of guilt?
I didn't ask her.
No. Do we hear any confession of guilt?
No, sir, you do not.
Very well. Thank you.
Thank you. State? All right, sir.
The preponderance of the evidence, not one piece of evidence, you absolute dingbat. But I know you have to do your best job with the worst cards.
Thank you for appearing
Hey,
today.
Bridget.
Excuse from further testimony. Have a good day.
Let's get to the
State
next
calls
one.
Kendall Davidowski.
I do have a good pause game.
Good morning. Please come up to the witness stand. Please be seated. Make yourself comfortable and let me know when you're ready to proceed.
You missed that he called her, said they had removed something from her house and found skeletal remains, and she said, okay. It was just again to imply there was no emotional reaction to anything.
All right, please state and spell your full legal name.
Kendall Davidowski, KENDALLDAVIDOWSKI.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God? Thank you. Please proceed.
Tøj, you weren't here yesterday when I had to drink my Lord to get through it. Yes, it tested it slightly yesterday.
Can you please introduce yourself to the jury?
Kendall Davidowski.
Did you know Michael Shaver?
Yes, I did.
How did you know?
We originally worked together at Spaceship Earth over at Walt Disney World from November of 2014 until about May of 2015.
She was the girl he was banging while he was away from his wife, who got so harassed by Laurie that they broke up.
And what was your position with this?
I was an electrical apprentice at the time. He was a mechanic.
And at the point that you met him, where was he living?
He was living at the Warbirds hangar in Kissimmee.
What is that?
It's a airplane hangar, I mean.
And do you know Laurie Shaver?
I know of her, yes.
And what was, at the time that you met Michael Shaver, well, let me ask you this, at some point did you start a dating or physical relationship?
Yes, we did.
And what was the status of his relationship with Laurie Shaver while he was living at the hangar?
They were separated at the time.
Now, are you aware of what caused Michael to separate and move into that hangar?
I was told.
Based on hearsay?
Stage response.
Now, can we approach?
Sidebar, please.
Sidebar, sidebar. It's the best kind of bar when it's on the side, like all of Laurie's boyfriends. They had side wives and sidebars and mock. So, no, if she's not too impossible to understand, I'll try to catch up. That's why it's 125. Just to catch up with the rest of the trial, because it's a little bit. Don't rub it in. So was he banging her before she was banging all the other men? No. Remember yesterday we found out she had already had one in Connecticut who reached out to her again. And the year that Michael passed, she had 3. She had Jay, she had the bear Baloo, and then she met Travis within 1 year. And she got engaged to Travis 2 months after meeting him. So she's what they say in French, a town bicycle, because everyone has had a ride on her. Yeah, Disney is probably filing a cease and desist. Don't talk about us. Yeah, declaring unavailable due to the actions of the defendant. Yeah, we've seen that in other cases, that it's allowed to let hearsay in because it's directly linked to the victim or the subject, the suspect. She's one of those women who can't stand being single. As I said, le bicycle de cité. Brokeback Baker, you're back. And positively glowing. I assume your massage went extremely well. She was laughing at me at some point because she felt sorry for me. It was horrendous. It was hopefully it's worth it, because that's why it took me a little while to come back. I just had to, when I came home, just lie down for 15 minutes, and it was really bad. But it helps. She was all up that place. Now we want to know if Wix is riding that bicycle. Well, she needs someone. Travis can fill her up. Yeah, he put new tires on that, but there's still no tread marks on it. No, I think it was within half a year.
Of the events that led to why Michael Shaver was living in Wilkes.
He had told me why he was, yes.
And was that related to his arrest for domestic violence?
Yes, it was.
Now, did he talk, and I'm not going to ask you to say this, what he told you about that event, but did he explain what had happened that night to him?
Yes.
Based on that, did he express fear of Laurie Shaver or his safety?
Yes, he did.
And could you explain that?
He was concerned of his safety.
Rubia, you are, this is rebuttal witnesses, so this is the end of trial.
And the children's safety with Laurie and a gun.
Laurie, what?
and her having a gun.
Now, did you ever see Michael Shaver interact with his children?
I saw him interact with his son Aiden once.
And how was that?
They seem to get along very well.
And at some point did your dating relationship with Michael end?
Yes, it did.
And when was that?
About April of 2015.
And who ended it?
It was kind of a mutual decision. It was just becoming too much at that point.
And at that point, was he trying to reconcile with Ms. Shaver?
To my knowledge, yes.
Did you remain friends with him?
We weren't friends. We still worked in the same area, so I mean, we were cordial, but we didn't speak to each other.
After he went.
Thank you, Jessica Thomas, for donating to my massage fund. I will wish that poor little Filipino woman luck instead, Zach.
Missing, did you make attempts to reach out to him to see where he might be?
Yeah, somebody from Spatial Birth had contacted me, seeing if I had contacted him or heard from him. I had not, so I reached out to him around November of 2015.
And did you ever hear from him?
I believe he said that he had left and that his children, or he just left the children. But at that point, I didn't know if it was actually him or not.
You had, well, first of all, was that a phone call?
It was through Facebook. It was through Facebook Messenger.
And had you interacted with him in Facebook before?
Previously, before May, yes.
And when you guys were dating, did you also exchange text messages?
Yes.
So was there anything unusual about the contact that you had with him and the content of it?
It just didn't seem like him to just up and leave. He spoke so highly of his children, so I didn't see that happening. And it was very short. It was just all very short, one-word answers. So that was not usually like him.
And have you ever initiated any sort of sexual harassment claim against him?
No.
Nothing further, Judge.
Mr. Wiggs?
Yes. You never filed a sexual harassment claim against Michael?
No, I did not.
You know anybody that did?
I had a sexual harassment claim filed against me.
You're sexually harassing people?
Supposedly, yes.
Stop with the I'm just a friendly uncle voice. You sexually harassing people? Women can do it too. I know, Mr. Smiles, Mr. Wicks, sorry, that in our age, it's more of a compliment than sexual harassment, but younger guys can experience people being attracted to them.
According to
Okay.
Disney.
How long did you date Michael?
From about, I would say December of 2015, December 2014 to April 2015.
So you heard Michael's version of events,
Yes.
correct?
Yes.
Did you see any did he show you any photos of any battered women?
No.
Did he show you any police reports involving Michael?
You need to find the right one. I had some of those who just do the wellness massages, didn't really pop anything. Mine hurts like hell, but it releases so much pressure.
Michael Shaver? Okay. Did you ask him about that?
We had a brief conversation about it.
Okay. Did you ask him about any involvement with law enforcement or any agencies?
No.
You know who killed Michael Shaver?
I do not.
Thank you.
Redirect?
Ms. Kavadowski, was anyone involved with this case involved with making that claim against you?
According to Disney, it was Laurie Shaver.
Nothing further, Judge.
Any follow-up?
No follow-up.
Thank you for appearing today. You're excused from further testimony. Have a good day.
The state calls Robert Sellers.
So Laurie Shaver made a sexual harassment charge against her.
Good morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed. All right, please state and spell your full legal name.
Robert Sellers, R-O-B-E-R-T, last name Sellers, S-E-L-L-E-R-S.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. Please proceed.
Please introduce yourself to the.
Zach, not like the release you get. Yeah, Laurie filed a sexual harassment claim against her, not working for Disney, but still, that's why they weren't together. She was harassing them, stalking them. I believe she threatened her, but I'm not sure. But yeah, she filed with Disney. And I don't know how the rules are at Disney. There could be some rules about dating internally or something like that. I don't know.
My name's Rob Sellers. Currently an FBI agent. I was a Lake County Sheriff's Office deputy for 5 years, and that's how I'm involved with this case.
In 2014, what was your position with the Lake County Sheriff's Office?
At that time, I was on road patrol, assigned to Sector 3, which is the southern portion of Lake County.
And what were your duties be as someone on road patrol?
I'm as road patrol, just like the guys and gals that are on the street now, responding to 911 calls and answering calls for service in the southern portion of the county.
Now, did you have an opportunity to come into contact with Laurie Shaver and Michael Shaver in September of 2014?
Yes, sir, I did.
Were you the arresting officer of Michael Shaver from the domestic violence incident that has been discussed in this case?
Yes, sir, I was.
And when you got there, did you speak with both Laurie Shaver and Michael Shaver?
I did. I spoke with Laurie first and then ended up making contact with Michael a little bit later on.
It's fair to say that their stories contradict.
Yes, sir.
Now, were there photographs taken of both Laurie Shaver and Michael Shaver, along with some things that happened, conditions within the house?
Yes, sir, I believe Deputy Suttles took those photos.
I'm showing defense, which has been previously marked as states QQQ.
All right, sidebar, please.
Oh, so this was the guy who was at the domestic incident. I wish we could see these pictures because I'm pretty sure that she claimed that she had hit him over the head with a pew-pew. I bet he had some injuries to him. Laurie's jealous of his upgrade. Yeah, she seemed like a sweetheart, but we guys are stupid. When we spread our seed, we go back to the plow or the field that we plowed because, oh, I want to be with my kids. Sometimes you and your kids would be better off not being at the same farmhouse. I think so. I think that's when it happened. Come on, Mr. Sniffles. It's a police report. It should be allowed in.
Joint then, sorry, witness, what's been labeled as states QQQ. Do you recognize those photos?
Yes, sir, I do.
And what are those photos?
Those are photos that were taken the night of September 4th when we responded to, I guess the first couple photos are from when we met Laurie Shaver in the Target parking lot in Claremont. And then the last couple photos appear to be when we met Mr. Shaver at the residence and photos of the residence itself in Claremont.
Do they fairly and accurately depict the things that you had photographed as part of your investigation in this case back in 2014?
Yes, sir, they do.
They moved to states QQQ for evidence. It's the next number of exhibit.
All right, Mr. Wicks, without objection. Without objection, states QQQ will be entered into evidence as states number 68.
I'm going to go ahead and publish this photo number 1 from states QQQ. Who is that?
That's Laurie Shaver.
Photo number 2. What does this photo depict?
The photo of her left arm.
Photo number 3.
Lorraine, we are going through rebuttal witnesses quite fast. The daughter school teacher said never ever felt anything change with the daughter, never had any notion of anything. Then we had then we had the police lead investigator with the lisp back talking about a phone call he made when he told her that we found skeletal remains at the property, and he was just like, she was like, okay. Then we had Michael's girlfriend, who he was with shortly around 14, 15, and Laurie filed a sexual harassment lawsuit against her with Disney. This is an FBI agent who used to be a patrol officer who got involved in some of the DV incidents. They're watching the pictures. We can't see him, but apparently both of them have some injuries.
3.
Her right arm.
And photo number 4. Who is this?
Mr. Shaver.
And during the course of your investigation, did you observe any sort of laceration to his head?
Yes, sir.
Photograph number 5. Does that demonstrate that laceration?
That would be the laceration, yes, sir.
And photograph number 6. What is depicted here?
Their residence.
Photograph number 7. What is shown in this photograph?
Broken door to their residence.
Did Laurie Shaver give you any explanation about how that happened?
I don't recall.
Photograph number 8. What is that photograph?
I believe it's the other side of the same door.
Photograph 9,
2 firearms that were involved in the altercation.
photograph 10.
Be the bathroom.
Was that all the various areas of damage that occurred?
Yes,
That you took photographs of?
to the best of my recollection, yes, sir.
There's also some sort of indication of an entertainment center that was damaged. Did Laurie Shaver give you any explanation about how that happened?
Not that I recall.
Any explanation of the broken vase that
Not-
go along with the slide glass door?
There was, but I think there was a story from Mr. Shaver about how that had occurred.
But Ms. Shaver didn't know.
That's not that I recall.
Did Laurie Shaver give you any explanation of how Michael Shaver got the injury to the top of his head?
Yes, sir, she did.
And what was that?
She stated that Michael had the pistol in his left hand and that they fought over the pistol, and while they were fighting over the pistol, it somehow went up and struck him in the head.
Did Mr. Shaver have a contradictory version of that?
He did.
Were there any adult witnesses present when any of this happened?
No, sir.
No. Were there any attempts to talk to any of the children in this case, specifically the oldest child, Isabel Shaver?
There was, yes, sir.
Was she able to tell you anything about that?
No, sir.
Nothing further, Judge.
All right, Mr. Wiggs?
Did you see the murder?
We move this next. Madam Bailiff?
Bill?
Sorry, I'm receiving a call out. I apologize.
I'm sorry, what do you, may it please the court?
Yes, sir.
What do you go by now? What's your,
I go by Rob, but my legal name's Robert. Yes, sir.
okay, I know you're with the FBI now.
Yes, sir.
What's your title over there?
Special agent with the
Special agent, okay. What do you want me to call you? Special agent? Rob, okay. Rob, when this event transpired and you went to the scene, where was Miss Shaver?
She was on her way to the substation in Claremont, and she was told by dispatch to stop where she was at, which I believe was the target located off 50 in Claremont.
Right. Miss Shaver's the one that fled the residence for her safety, correct?
From my understanding, yes, sir.
Correct. Miss Shaver's the one that,
That's BS because she could also have fled the scene because she whacked him over the head with a pew stick and thought, oh my God, I better get out of here before he gets at me. So that's not indicative of anything. That's a stupid argument. And isn't it called taché? I thought it was taché.
fled the residence with the children to protect those children, correct?
Yes, sir.
Very well. Thank you.
All right, redirect.
No, sir.
All right, thank you for appearing today. You're released from further testimony and have a good day.
Thank you, sir.
Yes, sir.
State Caldwell and Nicholas.
We don't mention the Kell's name because he
All
took
right, good morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed.
he took my Tay away.
All right, please state and spell your full legal name.
Wilma Nicholas, WILMA,
And please raise your right hand and I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth? So help you God.
Yes.
Thank you. Please proceed.
Please reintroduce yourself to the jury.
Hi, Wilma.
Now, in September of 2014, was there a disturbance at your neighbor's house, the Shavers?
Yes.
And how did you become aware of that?
When I arrived home from work around 6 o'clock, Mike called me on my cell phone.
Not getting into anything specific that he said, but did you go over to his residence at that point?
Yes.
And when you met with him, how was he acting?
He was kind of frantic, distraught.
Did you observe any injuries to him?
Yes.
What was his demeanor? Was anything he said distraught? Anything?
He was really concerned.
Did he still appear to be under the effects of the event that placed him into that condition? Was he still troubled by whatever
Okay.
caused his injuries and things of that nature?
Not so much of his injuries as something else.
Just for the record, I'm going to object on Williams' basis under the Williams rule, the matters that we previously addressed at the court.
Yes. State.
Can we approach?
Yes, let's have a sidebar. Thank you.
So while Mr. Shaver was in this excited state, did he describe to you what had happened?
Yes.
What did he describe to you that happened?
He told me that they had an argument. Laurie was intoxicated and she had taken off with the kids. The injuries that I saw on him, he said that she had threatened to kill the children, him and herself, and he fought her with the gun and was trying to get the gun away from her, and she hit him over the head, the top of the head with the gun.
Did you see injuries consistent with that?
Yes.
Did you take pictures of those injuries?
I did.
Showing the defense what has been previously marked for identification of states 000. Showing the witness states 000. You recognize these photos?
Yes.
That was weird. I had a neighbor do a welfare check on me because she hadn't seen me all week and was afraid something had happened. My car hadn't moved. I talked to her yesterday. Someone's getting a little old.
And what are those photos of?
Those are the pictures that I took of Michael and his injuries and his torn clothes.
Does that accurately reflect how Michael Shaver was when you observed him that night after he described the events that you talked about?
Yes.
At this time, the state moves states 000 into evidence. This next numbered exhibit.
Mr. Wiggs, any objection?
Same objection, Judge Stanley.
Objections overruled. States 000 will be admitted into evidence of states number 69.
The time frame that you knew Mr. Shaver, what was his approximately height and weight?
He was about 5'6", almost the same height I think as me, and about 150 pounds.
I'm going to go ahead and publish photograph number 1 from the previous exhibit of what were you trying to show with this photo?
No, because I was talking to an old lady who thought she hadn't seen me in a week. So she observed him with torn clothes and injuries. That's what I gathered. So I don't know if any other tasty morsels was in there. You put it in G-Ad.
Barely. Okay. You can tell that he has blood coming from the top of his head and it's come down onto his shirt. His shirt has been torn in multiple areas here in that photo.
And the tearing of the shirt, did you attribute that to Laurie Shaver?
Yes.
Photograph number 2.
Here you can see the top of his head and the injury a little bit better here.
Did you take a top view of that in photograph number 3?
Yes.
Photograph number 4, what are you showing here?
He had the keys to her truck in his pocket and she was fighting him and tore his shorts to get the keys out, and she succeeded in getting the keys out.
And did he express why he was trying to prevent her from having those keys?
Because she was drunk and she was taking off with the children.
Nothing further.
All right, Mr. Wiggs.
Hey, please, court.
Yes, sir.
Do you know who was charged out of this incident with any criminal offense?
Yes.
Who?
Mike was.
Correct. So you get Michael's version of the events, and only Michael's version, correct? Correct, ma'am?
Yes.
And Michael ends up being prosecuted, correct?
He does.
Okay. So you would agree the state attorney's office had a different opinion.
Objection, Your Honor. Charging decisions of the state.
Sustained.
So evidently, people were dealing with Michael Shaver. Michael Shaver ends up prosecuted, correct?
Based upon.
Ma'am?
Yeah.
Correct?
Yes.
Okay. So what you got is a one-sided interview with Michael, correct?
I have heard her myself.
No, ma'am. You spoke to Michael, correct?
Yes.
Okay. Did you interview Laurie Shaver?
No.
Okay.
Please get up there, defense, and say, why didn't you talk to Laurie Shaver? Because I was afraid of her. She was always yelling. She was always scaring me.
Do you know who the initial aggressor was that caused that injury to Michael Shaver other than what Michael Shaver told you?
I wasn't there in person.
Correct. Correct. Thank you.
Correct.
Redirect.
Yes, sir.
All right. Thank you for appearing today. You're excused from further testimony. Have a good day.
The state calls Rebecca Urbanowski.
Rebecca Urbanowski. It's moving like a pig. No, that's not fast.
Good morning.
like
Please come up to the witness stand. Please be
crap
seated. Make yourself
through a
comfortable.
pig.
Let me know when you're ready to proceed. Thank you. All set? All right. Please state and spell your full legal name.
It's Rebecca Urbanowski, REBEKAHURBANOWSKI.
All right. Thank you. Please raise your right hand and I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth? So help you God.
I do.
Thank you. Please proceed.
I am Rebecca Urbanowski.
And do you know Laurie Shaver?
Yes, I do.
How did you meet Laurie?
I met her at the gym through her boyfriend at the time.
And did you work for the gym?
No, that was a proffer to figure out if she had been on social media.
Yes, Gold's Gym in Claremont.
And what position did you have there?
I was a personal trainer there.
And when you say her boyfriend,
Jeremy.
No, this is rebuttal. Rebuttal for the case. That's why all of these witnesses, as you can clearly hear, are called by the state. That's why the Mr. Wicks goes number 2 and is the most condescending a-hole in the world.
Townsend.
did you ultimately start a professional client-trainer relationship where you were training her?
Yes, I did.
And what was her general physical status at that point?
She was in pretty good shape. She had lost a substantial amount of weight on her own already, but she was in good shape, better than most new clients that I get.
Was she doing strength training?
Yes, we train twice a week.
And do you know Travis Filmer?
Yes, I do.
How do you know Travis?
That is my brother-in-law now.
Who is your husband?
My husband is Austin Filmer.
And when did you get married to Austin?
October 28th, 2016.
Now, did you legally take his last name?
I did not.
So on your driver's license, it says Rebecca Urbanowski.
It still says Urbanowski, yes.
Have you ever had any sort of social media profile where you had the last name?
Yes, I have, yeah.
But if it were said that you never took his last name, that would be a correct statement.
Legally, no, I never took it.
Did you ever socialize with Laurie Shaver and Travis Filmer?
Yes, I did.
And when did they start dating?
I don't know a specific date that they started dating, but I know that they were in contact after they had initially met and hung out.
When approximately did they start hanging out?
They met the first time at the end of February of 2016.
And when was this compared to when she was dating Jeremy?
It was kind of in like that gray area, I think. When Travis and Laurie first met that night, Travis had already had a girlfriend at the time. So after that night, they actually left. We had gone to Old Town, and Austin and I were kind of dating at the time, or starting to date. And both the boys came, and Laurie and I had been there. And when Austin and Travis showed up, Travis felt it was uncomfortable because he'd already had a girlfriend at the time. He didn't want it to look like a double date. So they left probably 20 minutes after getting there.
The period of time when she was dating Jeremy, was there like a hard break to that? And then Travis came to the picture, they kind of overlapped. What was the deal there?
They kind of felt like they overlapped. So it was kind of a gray area where when one stopped and then the other one.
Remember yesterday in her testimony, she said she never saw him again after the day of the unaliving, which were, she could clearly remember it, May 2016. But she was dating Travis at the time after breaking up with Jeremy, who then did it in 2016. It's almost like she's lying a little bit. But I love that she was banging a married man and went hunting for a guy in relationship. Because she doesn't like that new car smell. She just wants one that's worn in.
Officially began.
At some point, did you live with the defendant?
Yes, I did.
And is that at the residence in Claremont?
The Sandy Pines, correct. Yeah.
And when did you start living with her?
That would have been May 7th, 2016.
And at any point while you were there, would Jeremy come over, stay overnight, or anything like that?
Never overnight. I've only seen him there.
My neighbor is 86 years old, so no thank you.
One time when I was there, but I had moved in at that point.
And like, what kind of day are we talking about when Jeremy would come over?
It was during the afternoon time.
Around your lunch break?
Yeah, I would say so. Yeah.
And while you were living there, did you see Laurie with multiple phones?
Yes, I did.
And what was her phone number at the time?
Offhand, I can't say exactly what it was. I just have the one that I have now.
Is that the same number that you had back then, or has that changed?
It would have changed. Yeah.
Now, during the time that you were friends with Laurie Shaver, was a concrete slab put in the backyard around a fire pit?
Not when I initially moved in, no.
Were you friends with her or socializing with her when that occurred?
Oh, yeah, sorry. Yeah.
And were you and Austin present when the cement slab was placed out?
I was actually at work most of the day. When I got back, it was there because I worked majority of the day.
During the time frame that Laurie has been with your brother-in-law, Travis Phil, has the relationship between Austin and yourself changed with Travis?
Very much so. We rarely see Travis anymore. For a while, we couldn't even get in contact with him because we found out that all of our phone numbers were blocked from his phone. Austin and Travis have always been very, very close. They're fraternal twins, and they've been through a lot in life together. They used to go fishing a lot, hanging out, but we don't see anything from him, or we don't talk to him. We don't socialize. The last time I've actually physically seen him was when their grandfather passed away at his funeral. That was the last time I physically saw him.
Did Laurie Shaver ever tell you what happened to her prior husband, Michael Shaver?
Just that he had left.
Nothing further.
Mr. Wiggs?
So y'all have a bad relationship.
Who?
Austin and Laurie and Travis, correct?
There is no relationship.
Correct.
Sure.
So that's what you have to testify here to tonight? That there's a bad relationship? Bad blood?
I'm not allowed to say the JC word, so I'm going to use Jamieism. Jeeps or Pete's or whatever it is she always says. Could you be more of a condescending a-hole? Do you think it's possible to sound more like a condescending douche canoe? See, all you have to testify about here today is a bad relationship? No, it's to lay the foundation in the jury's mind that she has done this with every single man she's been with, trying to isolate them from friends and family. If you can't grasp that and you can't talk your way out of that, you are what Jamie would call el stupido, which is stupid in Spanish, Irish.
I guess.
You lived in the residence in a certain period of time, correct?
Correct.
Didn't see a homicide committed there, did you?
No, I didn't.
Didn't see anybody being buried, did you?
No, I didn't.
Okay. And you know there was,
No one
she
did.
was dating Jeremy for a period of time, correct?
Yeah, for a little bit.
You have sit downs with Jeremy?
I've seen him once there.
Okay. So he was at the house once. You moved out. What was the time period you moved out?
It was the day after their wedding. So it'd have been 2008, January 1st, 2000.
You're talking about Travis and her.
Yeah, Travis and Laurie's wedding, yeah.
So were you back there in the period of time when she was dating Jeremy?
Was I back there? What do you
Were
mean?
you living with Laurie?
When I moved in May, they weren't really dating. It was kind of an up and down.
Thank you.
Redirect?
The wedding that you referred to, that was in, what year was that?
That would have been December 31st, 2016, sorry.
And had that been referenced, you were a guest at that?
Yeah, because we were the next day, we were moving into, Austin and I and Kendall were moving into our new home.
Had that event been represented to you to in fact be a wedding?
But yes, it was.
And she was in a white dress?
Yeah, when I had come back from signing our lease and everything, she was already in her dress.
Wedding cake?
There was a wedding cake, yep, a dress.
everyone there thought that Travis and Laurie were being married at that time.
For sure.
Nothing further.
All right, Mr. Wicks?
Nothing.
Nothing. All right, thank you for appearing today. You're excused from further testimony. Have a good day.
The state calls Katina Vasquez.
Danielle, when I come to visit you in Florida, can you get me a personal trainer class with her? Just saying. I like a woman who lifts. I'm sorry. Oh, thank you, Tammy. I can't falsify
Good
the
morning.
record.
Please come up to the witness stand. Please be seated. Make yourself comfortable, and let me know when you're ready to proceed. All right, please state and spell your full legal name.
Katina Vasquez, Katina, V as in Victor, Asquez.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
I have learned one thing about Floridian women. They like to sleep around. Maybe it's only because I know Laurie Shaver, but she is now my fixed point for every girl in Florida.
Yes, okay. Thank you. Please proceed.
Yes, especially married women in Florida apparently has at least one or two on the side. I'm just doing the Florida culture.
Introduce yourself to the jury.
Hi, I'm Katina Vasquez.
And do you know Laurie Shaver?
Yes, sir.
You see her here in the courtroom today. You can identify her by something that she's wearing.
No, not a great way to avoid drama, but the airplane I'm going to take home after a week is a wonderful way to get out of trouble.
A black jacket.
And how did you meet Laurie Shaver?
Through Scott Amateur my ex-fiance.
And
Everyone except little D. She is a virtue of innocence.
do you remember approximately what year you would have met Laurie Shaver?
I believe we started dating 2006, 2007, and we ended the December 2014.
And did you know Michael Shaver?
Yes, sir.
And how did you meet him?
Through Scott.
And were Scott and Michael Shaver close friends?
Yes.
What was your through meeting Laurie through and Mike? Did you develop a friendship with her?
Yes, sir.
Did you develop a friendship with Michael Shaver?
Yes, sir.
Closer friends with her than Mike?
Yeah.
And did you ever go over to the Shaver residence after Mike disappeared in November of 2015?
Yes, sir.
And why were you going over there?
She said he had left, and I went over just to see how she was doing.
And did Laurie say anything to you about where Mike was?
No, just that he left in a black SUV in the middle of the night.
And did she reference anything to you about Mike's work or whether or not he was still working there?
That I don't think he was going to work.
And did she tell you specifically how he informed his employer that he was no longer going to work for them? You don't remember anything about that?
Mm-hmm.
Okay. While you were there, did you see anything that you thought was unusual based on the story that she gave you that Mike had just left?
Yeah, all his stuff was still there.
When you say all this stuff, what do you mean?
She was in the back.
We don't really have any catchphrases other than La Lalas de Tuna and she's a town bicycle. Remember when she said it was an informal ceremony, a commitment ceremony? It had nothing to do with a wedding. Thanks to Brandy Churchwell, you can now see pictures never released before. This is the informal, not a wedding commitment ceremony that they were having in the backyard, right next to the fire pit. And from inside of the house. That's a horrible wedding cake. I hope they didn't pay for that one. But absolutely not a wedding at all. No way, Jose. That's why she's in a wedding dress. Not a wedding. Not a wedding at all. Totally informal. Everyone was just showing up thinking, it's nothing. It's not like it's a commitment, anything but a commitment thing. So, yep. No one coming over and hanging out smelled anything, but the neighbor did. Well, it depends on when the gas pockets get out of the earth. Yeah, well, she treated it like she treats her husband, like dirt. Can you hi? I'm Jimmy for us for Stephen Frenner. He missed it. I didn't hide Jimmy to anyone. Yeah, I know it wasn't a wedding, but she has to say that because she knew she was still married. But everyone participating, like we heard from the last witness, was invited to a wedding. It didn't become a commitment ceremony until she got caught.
I'm Jimmy. How y'all doing?
Or she was on the porch on the phone, and I went to the bathroom, and like all his stuff was like still in the
Edward.
closet and stuff, and the car was there.
Talk about clothes, toiletries, things of that nature? Is that yes?
Yes.
Okay. Did you see any extra phones in the residence?
There was a black phone on the counter.
Now, while you were there, was the defendant trying to sell or get rid of any of Michael's property?
We haven't heard anything about that, but no, I can't see. I can see a Bible, or what looks like a Bible. So I don't know.
Yes.
And what was that?
She was on the back porch on the phone and
Weird,
was trying to sell guns. And I asked, why are you selling Mike's guns? Isn't he going to need them? And she said she bought them. They were hers.
Now, were you familiar with the domestic violence case where Mike Shaver was arrested in?
I can tell you, it's La Lalas de Tuna, and it's open a lot in the beginning, probably.
2014.
Yes, sir.
And how did you become familiar with that?
Lori told me.
And what did she tell you about that 2014 domestic violence case?
At her house, she said, because Mike had come back into the home, he was living at an airport. And she said that, and I was kind of like, why is he here? Kind of. And she said that she was working with being honest with her therapist and that Mike didn't touch her. Like all the wounds were from her. She threw a vase and broke a door. It wasn't Mike, and he was actually trying to stop her because she had a gun and was trying to kill herself.
When did your friendship with Laurie Shaver end?
2017.
And at the time in 2017, when the friendship ended, did she make any statements to you relating to Michael Shaver still being alive?
Yes, sir.
And what did she tell you?
She was going to move up to Gainesville because I had a son and couldn't afford daycare. And she was going to drive up, look for houses. She got my Starbucks order, took pictures of the kids in the car, and then disappeared. Didn't hear from her for 2 weeks. Took me off Facebook. 2 weeks went by, and she finally got in touch with me and said that she panicked because Mike was in the parking lot. And she thought maybe Scott told Mike that she was coming up there and he was stalking her. And I'm like, well, why haven't you called me? And she said that the cops had her phone and the truck was at the police station because he was tracking it.
And this is in 2017 that she was saying Michael Shaver was stalking her.
Yes.
So clearly after May of 2016.
Yes.
And clearly after September of 2016 when the cement slab was put in her backyard.
Yes.
Nothing further.
Mr. Lakes?
Please, the court.
Yes, sir.
Did you see the weather?
Ma'am, did you file a letter to support Laurie Shaver on an injunction?
No.
No? You never submitted any letter to DCF?
No.
She's a friend. Used to be.
Did Michael ever obstruct your relationship with Laurie?
No.
Okay. Now, when you said that Laurie was selling property out of residence, do you have any understanding whether that was only Michael's property or whether it was marital property?
It was.
That she was by law prohibited in any manner?
She just said the guns, and I know the guns were theirs. And
Okay. Do you know anything about marital labor and contribution to the marriage?
no.
Correct. So you just assume this is Michael's property and she had no right to touch it, correct?
They were their
Child Protection Services.
guns. He built and restored guns. So
Do you know why the property was being sold?
No,
Do you know if it was maybe the need for groceries and necessities?
no,
Do you know if there was any plan to aid anybody with those funds to escape detection of a crime? Did you ever witness a murder or any event occur at the house?
no,
Now, the event that you spoke about an incident that occurred at the house, a crime, a battery, were you there to witness that event?
no, sir.
Correct. Thank you.
Redirect. All right, thank you for testifying here today. You're excused from further testimony. Have a good day. Next
Did
witness.
you?
At this time, the state of Florida rests.
Oh, they rest. That's nice. Did we go on a break?
Thank you.
All right, let's take the jurors out at this point.
So we're live again. Oh, almost. We're live again. Child Protective Services was involved. Remember yesterday when she told us they were so scared of Mike that Child Protective Services offered her to go into a kind of witness protection program, change their social security, everything. Which was a lie because no, they didn't. But in her mind, they did. You're so mad. What you so judgy? Fun sticks. Is that something you put in the La Lalas de Tuna? Wigs are massively cringe. And DCF doesn't help you get fake names and social security numbers. No. It's such a stupid idea. Or maybe because she threatened to unalive her kids. The problem is we don't know what's in the DCF files. Her lawyer is talking different today than while he was questioning the defendant yesterday. Yes, he has been doing that all the time. When he tries to demean the person on the stand, he talks to you like a creepy uncle who kind of want to imply that you're too stupid to talk to him. But yeah. Is Brandy going to come on your channel and talk about this? I don't know. If she reaches out to me, she's always more than welcome. I love having Brandy on. I can't wait for closing. Well, I can because I'm probably going to go sleep when Mr. Wicks is giving closing arguments because that's going to be such a fantastic tale that I would think I'm sleeping. DCF doesn't put families in protective custody. It's unbelievable that Laurie expects people to believe her. Have you watched this trial? It's absolutely insane. She well, she had spilled so much BS that anything she said on the stand yesterday, even her name, I would have a hard time believing. She's absolutely crazy. Travis and Loris was legally married a year after their commitment bridal shower. Well, they couldn't be because at that time her husband wasn't deceased or declared deceased, and she never got a divorce from him. So Travis and Laurie, to this day, still isn't legally married. That's why she said on the stand that it was a commitment thing. It wasn't a marriage because she can't legally marry someone else when her husband is still alive and she hasn't divorced him. She claimed to Travis before that she had been divorced. It had been Mike had been in a room next to the room she was in at the courthouse to sign the divorce papers, but no such things exist. You were a CPS investigator for years, so you can get me a social security number and a new name. Everyone is always asking, where's Jamie? Do you know how that makes me feel? I'm not good enough. You're only here for Jamie. Jamie's working. She'll be here in a soonish time. Laurie would be a Great sport fish, dolphins, my fishermen, because you keep one on the hook in water until you catch a second one. I thought it was because she was like Zach, always exaggerating the size of the fish. No Sean Bird movie tonight? Maybe. It's Friday the 13th. If we are done early-ish with the verdict watch, Sean Bird, I think, might be showing Friday the 13th on the Discord server. So look out for that if you're a member of the Discord. If you're not a member of the Discord, what you doing? Get in there. Oh, they did? Well, that'll be a long time after the not wedding then. Because he wasn't declared deceased until 2018, and they got married engaged in 2016, I believe, married in 2017. Wasn't that what she just testified to? Why do you need a social security number and another name? What have you done? Because I'm going to Florida and shake some of that tuna salad, because apparently every, except present company, lady in Florida likes a little bit on the side. So I'm going to be Senor Powers, and I'm going to be an international man of mystery from Holland. And I'm going to use my fun stick over there. And then when I go home, I'm back to being the baker. Gracias, Mom of 10. Yeah, we clearly remember poor little Harmony Montgomery. That's why when she said yesterday that, well, they offered me this and that. No, we saw Harmony Montgomery stay with a family of crackheads in a house with no heat because a DCF guy waved to her. That was enough for him. I meant the state. What state? Oh. Laurie would be good bait for sport fishing because she smells like tuna. Florida is where the criminals go. I'll fit right in. Make concrete great again. No, that'll be a way too troublesome thing to go through. I'm behind everyone else. I'd be in my home for 5 years and my neighbor wouldn't pick up the phone. It's too hot in Florida. Yeah. From Holland, let's hear some Dutch. Let's see if you can keep up the act. I have a Dutch accent. Everyone says that. So I will fit right in and everyone will say, oh my, he's one of them Dutch people. Holland, Michigan? No, Holland is what we call the Nederlanden, or the Dutch countries. Well, me and Tom Gillis, we have to figure out some way to share her, because we are both very infatuated with this woman. But I think she's a woman enough to handle 2 men at a time. We can call her the Star-Kissed Unaliver. What's Star-Kissed? It's freezing in Scotland. Temperatures have dropped dramatically. We are all in winter coats and boots now. Yeah, I saw in Italy it was snowing yesterday. We had, last week was hot as all the balls. And yesterday it started raining and it felt like it was about to go below freezing. You can just feel that bite in the air. The Low Countries, yes. Amsterdam is the bomb. Can't remember it. Was there in the 7th grade, so I don't know how good it is. You're trying to give me a better cover. Thank you. But my Dutch accent will spoil it. I live with a concrete professional. I'm about to pepper him with questions. You should. What's happening now? Starkist is tuna. Someone have already told me that. I'm making up dreams now. Don't you always make up your dreams? Been to Denmark twice. My friends tell me that in the winter Danes get depressed because it's so cold and dark for so long. Not enough sunlight. Do you get like that? I try to hit a tanning bed every 2 or 3 weeks in the wintertime. Not because of the cold. I like the cold, but because you don't see daylight. It's gray for long. Well, of course, if it's not cloudy, but most days from November till late February, it's just gray, and you only get those few days of a little bit of sunshine. So, yeah, we get depressed a lot in the wintertime, but that's why hit the tanning bed, eat some D vitamin. It's all good. Yeah, they regulated the Puff Puff Pass. Yes, I am going to cover the Carly Craig trial. Hopefully, well, this will go to Verdict Watch. It's 11 now. I had hoped they would be done by noon. If they're done by noon, I'm going to make myself some dinner. Then I'm going to come back for Verdict Watch, where we're covering the hearings in the Carly Craig case. So we're ready to pick that up. It should be starting Monday or Tuesday next week. So don't yell at me. That's what I call a good weekend. I would love West Michigan. All of your fellow Dutch people live there. Never been to Michigan. The Dutch English accent is a stuff of horror. Yeah, just listen to it. You know that indentured area was there before they poured the concrete. I don't know anything about concrete. I'm a baker. This one? Is he going to do this one tonight? Or what else has been out there? Sarah Boone? He's a little behind on the Sarah Boone with all the filings. So, yes. No, we probably won't be off Verdict Watch. So I could throw everyone over there and they could give a like, and they probably won't understand much of the Deutsch. But, well, our Dutch friends and Swedish friends, well, not the Swedes, they don't understand anything. But the rest of the Europeans probably would understand the German. Too little snow in Denmark winter, so it gets kind of depressing. Yeah, it's just muddy and wet. That's why we get depressed, and it's dark. We have different shades of gray. It's beautiful. Always with the positive mood, those Swedes. Starkist is the chicken of the sea, says Charlie Tuna. So does Jessica Simpson. Don't overdo the D vitamin. I get 2 D vitamins, no, 1 D vitamin pill a day. I'm probably going to start next month, and then I'll do them until March come around. The Carly Craig case is fascinating. Yeah, and horrifying.
We're back on the record in case number 2020-361.
And there was one we missed Tuesday, I believe.
Your Honor, I made the appropriate changes to the jury instructions that would ask that Mr. Wiggs double check especially the self-defense instructions, since there were a lot of changes made to that to make sure it's accurate.
Please let me know once you check the instructions, Mr. Wiggs.
And prior to calling the jurors back in, I'd like to have a sidebar with the parties and with the deputy, if you would. Okay.
What? The deputy?
Judge, do you have a stapler? Big stapler? Okay. I'll buy it.
Tim Swoop, if you go into the Discord, I have my recommendations for Baker. Baker, take a look. That's normally where I go look when I don't have anything else. If you tell me on a stream, I'll say, oh, I'll look at it. And I'll forget it before. I'll wake up the next morning and it says John Denver on my plate. And I think, Jamie told me a joke yesterday, I forgot. And then I'm throwing it out. So recommendations for Baker is the one. Isabella is in court. She's sitting on the same bench as Brandy, a couple of feet away. Well, jury instructions, whenever when they have, normally they do the half and then they do the closing statements. If they do it like that again, we skip the last half. We don't need to know all of that. Will someone put his stapler in jello? Well, they found weed in her system, so they might go with she had a psychosis because of the weed as well. Oh yeah, bet that's a wonderful area. Are the jurors going to be sequestered? That might explain the deputy. No, it's probably the deputy could be keep an eye out in court or something like that. Jury won't be sequestered in this case. It's not big enough. Is she sitting on her mother's side? I thought Brandy was sitting on the prosecutor's side. I don't know. I can't tell you that. Yes, Sarah Boone has a stapler. That's how she makes her pants. No mention at all about her son other than she has one. Reefer Madness. Yes. Pet the furry wall. I don't have a furry wall, but I'll pet it. But I don't think we ever heard about the deputy being called before, but normally it could also be that have a sidebar about which numbers can I get you on because the judge doesn't expect it to take that long. My chat right now thinks 96% would vote guilty, 3% not guilty. So that's a hung jury. Yeah, Brandy said the other day no one was on the side, but it could be that there's so many people now that you just shifted over because she ain't got no friends. Whee, I'm tired. What do we think she's listening to? Oh, it's the sidebar she's listening to. I'm an absolutely douche canoe. I know that. Or maybe it's I want it that way. Your wife, just leave her. Your girlfriend, just leave her. My Lala's the tuna is there for you now. Tell me why ain't nothing like a tuna. Tell me why ain't nothing like tuna. Tell me why don't you wanna leave your wife? I got your name on my coochie pot. Little D and Jamie, you do have the links if you want to stop me from singing. Boom, boom, boom. Oh, sidebar 4. I'm not doing my accounting good enough today. Salad isn't good for you. It happens when I'm a little bit tired. Well, turn down your audio just because I have such a wonderful voice. Don't turn it
All
up
right,
too high.
please bring in the jurors. Thank you.
My White Bicycle by Nazareth. I'm a white bicycle. No, everyone's asking about that case. I don't know anything about it. I know something about a hitman. Someone want to go to Thailand. I know everyone is everyone to cover that trial. There's amazing people out there who's going to cover that trial. I think I is going to do it. Recovery Addict. I think who was I on the other day in chat? I can't remember. T something is going to cover it. Everyone is going to cover that case. So I'm just going to do what I always do: sneak under the radar and cover the Carly Gregg case, because Alderson is next week too, I believe. Don't know anything about it. Didn't cover 1 second of it. So I'm not going to start now. I'm going with Carly Gregg instead, because the other one, I know it's a crazy story, but when you didn't get in on the ground level, you'll have to sit here the entire time and say, who's that? And everyone in chat will say, well, that's the neighbors, cats, dogs, owners, pets, bird keeper. Oh. I'm making it easy for the Americans. Thank you, Texas. Well, jury selection starts Monday.
I see that all the members of the jury have returned. Please be seated. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Laurie Lee Shaver, the defendant in this case, has been accused of the crimes of murder in the second degree with a firearm and accessory after the fact to second-degree murder. Introduction to homicide. Laurie Lee Shaver is accused of murder in the second degree in count 1. Murder in the second degree includes a lesser crime of manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful.
One of those lens.
If you find Michael D. Shaver was killed by Laurie Lee Shaver, you will then consider the circumstances surrounding the killing and deciding if the killing was murder in the second degree or was manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. Number 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means, with usual ordinary caution and without any unlawful intent, or when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Laurie Lee Shaver may be found guilty of murder in the second degree or any lesser included crime. Murder second degree, count 1. To prove this crime of second degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Michael D. Shaver is dead. 2, the death was caused by the criminal act of Laurie Lee Shaver. 3, there was an unlawful killing of Michael D. Shaver by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove that the defendant
indent
had an intent to cause death. An issue in this case is whether Laurie Lee Shaver did not have a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation. In order to find that the defendant did not have a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, A, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and B, a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and C, there was not a reasonable amount of time for a reasonable person to cool off, and D, a reasonable person would not have cooled off before committing the act that caused death, and E, Laurie Lee Shaver was in fact so provoked and did not cool off before she committed the act that caused the death of Michael D. Shaver. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, you should find her guilty of second-degree murder. Possession of a...
You should not find her guilty.
Yes, sir. I will read that again. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, you should find her not guilty of second-degree murder. Please make that correction. Thank you. Possession of a firearm and discharge causing great bodily harm or death. If you find that...
Again, the dog pond was already buried. She more than likely just dragged him out there, threw him in the hole, and covered him. That's why it's only 3 feet deep. And again, it's not that big a problem. She was in pretty good shape. We heard from a personal trainer today. And she was fit enough to beat him earlier. It's not that hard to put a body in the ground. Just wait till it's dark so your neighbors don't see it.
Laurie Lee Shaver committed murder in the second degree.
Yes, we are reading the jury instructions, so everyone has done everything.
And you also find beyond a reasonable doubt that during the commission of the crime, she discharged a firearm and in doing so caused great bodily harm to or the death of Michael D. Shaver. You should find the defendant guilty of murder in the second degree with discharge of a firearm causing great bodily harm or death. Great bodily harm means great is distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. If you find that Laurie Lee Shaver committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime she discharged a firearm, you should find the defendant guilty of murder in the second degree with discharge of a firearm. If you find that Laurie Lee Shaver committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime she actually possessed a firearm, you should find the defendant guilty of murder in the second degree with actual possession of a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. The frame or the receiver of any such weapon, any firearm, muffler, or firearm silencer, any destructive device, or any machine gun. To actually possess a firearm means the defendant, A, carried a firearm on her person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. When there are lesser included crimes or attempts in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is accused, there may be evidence that she committed other acts that would constitute a lesser included offense. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of murder in the second degree is manslaughter. Manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1, Michael D. Shaver is dead. 2, Laurie Lee Shaver intentionally committed an act or acts that caused the death of Michael D. Shaver. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. Aggravation of manslaughter by carrying, displaying, using, threatening to use, or attempting to use a firearm. If you find that Laurie Lee Shaver committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime she personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find her guilty of manslaughter with a firearm. A firearm is defined as any weapon which is designed to or may readily be converted to expel a projectile by the action of an explosive. The frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. If you find that Laurie Lee Shaver committed manslaughter, but you are not convinced beyond a reasonable doubt that she personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find her guilty only of manslaughter. Accessory after the fact to second-degree murder. To prove the crime of accessory after the fact to second-degree murder, the state must prove the following 4 elements beyond a reasonable doubt. Number 1, a murder in the second degree was committed by another. 2, after the murder in the second degree was committed, Laurie Lee Shaver maintained, assisted, aided, or attempted to aid that other person. 3, at the time Laurie Lee Shaver knew that other person had committed At that time, Laurie Lee Shaver knew that other person had committed the murder in the second degree. 4, Laurie Lee Shaver did so with the intent that other person avoid or escape detection, arrest, trial, or punishment. The elements of murder in the second degree have previously been given to you. It is not necessary for the state to prove that Laurie Lee Shaver's assistance was successful in allowing another person to avoid or escape detection, arrest, trial, or punishment, nor is it necessary for the state to prove that the other person was convicted. The intent with which an act is done is an operation of the mind, and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence, like any other fact in a case. When there are lesser included crimes or attempts. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is accused, there may be evidence that she committed other acts that would constitute a lesser included.
He got convicted in the DV case. She didn't. We haven't heard anything else. Yes, they do. And this is how most judges do it, way too fast and not explaining what it means. But they will get a copy of them. Normally, they give one to each of the jury members.
Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser included crime indicated in the definition of accessory after the fact to second-degree murder is accessory after the fact to manslaughter. Accessory after the fact to manslaughter. To prove the crime of accessory after the fact to manslaughter, the state must prove the following 4 elements beyond a reasonable doubt. Number 1, a manslaughter was committed by another. 2, after the manslaughter was committed, Laurie Lee Shaver maintained, assisted, aided, or attempted to aid that other person. 3, at that time, Laurie Lee Shaver knew that the other person had committed the manslaughter. 4, Laurie Lee Shaver did so with the intent that the other person avoid or escape detection, arrest, trial, or punishment. The elements of manslaughter have been previously given to you. It is not necessary for the state to prove that Laurie Lee Shaver's assistance was successful in allowing another person to avoid or escape detection, arrest, trial, or punishment. Nor is it necessary for the state to prove that the other person was convicted. The intent with which an act is done is an operation of the mind and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence, like any other fact in a case. Justifiable use of deadly force. It is a defense to the crime of murder in the second degree, including lesser included offenses, if the actions of Laurie Shaver constituted the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm. Laurie Lee Shaver does not have the burden of proving that she was justified in using or threatening to use deadly force, or that Isabel Shaver was justified in using or threatening to use deadly force in the defense of Laurie Shaver. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt the defendant was not justified in using or threatening to use deadly force. The law on justifiable use or threatened use of deadly force in Florida is as follows. Laurie Lee Shaver was justified in using or threatening to use deadly force, or Isabel Shaver was justified in using or threatening to use deadly force in defense of Laurie Shaver if she reasonably believed that such force or threat of force was necessary to prevent imminent death or great bodily harm to herself or another, or the imminent commission of attempted first-degree murder or aggravated battery against herself or another. The elements of attempted first-degree murder are: 1, Michael D. Shaver did some act intended to cause the death of Laurie Shaver that went beyond just thinking or talking about it. 2, Michael D. Shaver.
Why can't they read the Self-Defense Act? Because they didn't claim self-defense. So why is that, Brett? I don't understand that part.
Acted with a premeditated design to kill Laurie Shaver. 3, the act would have resulted in the death of Laurie Shaver, except that someone prevented Michael Shaver from killing Laurie Shaver, or he failed to do so. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. A premeditated design to kill means that there was a conscious decision to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The elements of aggravated battery are: 1. Michael D. Shaver actually and intentionally touched or struck Laurie Shaver against her will or intentionally caused bodily harm to Laurie Shaver. 2.
Yes, and I think they are overly complicated because every time a lawyer has been in a trial, they say, but why didn't they mention this part? So they put a gaggle of lawyers in a room and they wrote some standard. And every time a lawyer sees the standard, thinks, well, why isn't this part there? So it's way too complicated. It's stupid. It's I think it's a hindrance for the justice. We don't have jury instructions. We only have the very, very basic. Did they prove what was in the charging document? Then if it's not just normal violence and you have done that a few times, we don't get it. But if it's a new case, if it's a grape case, for example, they will read the law to you and say, these are the burdens to prove grape. We have read the law in the room with the judge. The judge is in there with us. We are 2 laymen, 1 judge, and we're doing it in a conversation. All of this is a waste of time. It's a waste of energy. And I know it'll never be changed because America is a country of lawyers, run by lawyers, who is always going to be the next lawyer to add another addendum to something. We go into a room, we have the charging document, and let's say, because I am doing a grape case right now, they will read to us, what does grape mean? And then we look at the charging documents and rely on our memory and notes for the testimony and say, I find it proven, I don't find it proven. We don't have to sit through 4 hours of mind-numbing text reading. It's stupid, it's a waste of time, and America should change their law system. I know everyone's saying we have the best in the world. I've been watching cases for more than a year now. No, you don't. You really don't, because there's too many lawyers and too little common sense.
Michael D. Shaver, in committing the battery, intentionally caused great bodily harm, permanent disability, or permanent disfigurement to Laurie Shaver, or used a deadly weapon. A deadly weapon is any object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design and construction. I believe there's a typo there as well. Great bodily harm.
Why didn't they have it pre-read?
And after great bodily harm, there is another one as well. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include bruises. If Laurie Shaver was not committing any crime other than alleged murder in the second degree, or any lesser included crimes for which the defendant is claiming self-defense or defense of others, and if she was in a place where she had the right to be, then the defendant had no duty to retreat before using or threatening to use deadly force, or before Isabel Shaver used or threatened to use deadly force. If Laurie Shaver or Isabel Shaver was in a dwelling in which she had a right to be, she had no duty to retreat and had the right to stand her ground and use or threaten to use force, including deadly force, if she reasonably believed that such conduct was necessary to prevent imminent death or great bodily harm to herself or another, or the imminent commission of attempted first-degree murder or aggravated battery against herself or another. The use of deadly force is justifiable if Laurie Shaver or Isabel Shaver reasonably believed that the force was necessary to prevent imminent death or great bodily harm to herself while resisting any attempt to murder her or another, or commit an attempted first-degree murder or aggravated battery upon her or another, or to commit an attempted first-degree murder or aggravated battery upon or in any dwelling house in which she or another was present. In deciding whether Laurie Shaver or Isabel Shaver was justified in the use or threatened use of deadly force, you must consider the circumstances by which she was surrounded at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use or threatened use of deadly force, the appearance of imminent danger must have been so real that the defendant or Isabel Shaver actually believed the use or threatened use of deadly force was necessary. Moreover, to justify the use or threatened use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use or threatened use of deadly force was necessary. Laurie Shaver or Isabel Shaver is presumed to have held a reasonable fear of imminent peril of death or great bodily harm to herself or another.
And I'm sorry I put it up to 1.5 speed, but he's just saying the same words over and over again, and it doesn't tell you anything. Great bodily harm is more than not great bodily harm. What is great bodily harm? It's stupidity. Just give them the law that states. And why is there 45 different explanations? She's charged with murder in the second degree. What are the rules for murder in the second degree? Why are we talking about self-defense? They never raise self-defense in 1 second. It's just confusing everyone.
Using or threatening to use defensive force that was intended or likely to cause death or great bodily harm to another if A, the person against whom the defensive force was used or threatened to be used was in the process of unlawfully and forcefully entering or had
Listed in where? In the charging documents, because she admitted she did it. So that's why if they believe that she had yeah, again, it's stupidity.
Unlawfully and forcibly entered a dwelling, residence, or occupied vehicle, or if that person had removed or was attempting to remove another against that person's will from the dwelling, residence, or occupied vehicle, and B, Laurie Shaver or Isabel Shaver knew or had
Baker singing Backstreet Boys, but better fund. Thank you so much, Toy.
reason to believe that an unlawful and forcible entry or unlawful and forcible act was occurring or had occurred. Presumption of reasonable fear of imminent death or great bodily harm does not apply if A, the person against whom the defensive force is used or threatened to be used has the right to be in or is a lawful resident of the dwelling, such as an owner, lessee, or title holder, and there is not an injunction for protection from domestic violence or a written pretrial supervision order of no contact against that person, or B, the person or persons sought to be removed is a child or grandchild or is otherwise in the lawful custody or under the lawful guardianship of the person against whom the defensive force is used or threatened to be used, or C, the person who uses or threatens to use defensive force is engaged in a criminal activity or is using the dwelling to further a criminal activity, or a person who unlawfully and by force enters or attempts to enter another's dwelling, presumed to be doing so with the intent to commit an unlawful act involving force or violence.
I can't tell you why her name is mentioned there, other than she is the defense.
Attached porch, whether the building or conveyance is temporarily or permanently or mobile or immobile, which has a roof over it,
The China coup
and is designed to be occupied
apparently
by people
was a big part of it.
Residence means a dwelling in which a person resides either temporarily or permanently, or is visiting as an invited guest. If you find that Laurie Shaver or Isabel Shaver, who because of threats or prior difficulties with Michael D. Shaver had reasonable grounds to believe that she...
It's because defense claims she did it. And if she lawfully did it, then Laurie is also innocent, which she would be anyway because she didn't do it. Again, it's lawyers writing a piece of paper that makes no sense. I can't help you with understanding it because I don't understand why you have to waste so much time talking about something. And again, it's just a technicality. No one in the jury box is listening to any of this. It's just
or another was in danger of death or great bodily harm at the hands of Michael D. Shaver. You may consider this fact in determining whether the actions of Laurie Shaver or Isabel Shaver were those of a reasonable person. If you find that at the time of the alleged murder in the second degree, Laurie Shaver or Isabel Shaver knew that Michael D. Shaver had committed an act of violence, you may consider that fact in determining whether Laurie Shaver or Isabel Shaver reasonably believed it was necessary for her to use or threatened to use deadly force. In considering the issue of self-defense or defense of another, you may take into account the relative physical abilities and capacities of Laurie Shaver, Isabel Shaver, and Michael D. Shaver. Defendant's failure to report a crime. The state has charged Laurie Shaver with the murder of Michael Shaver. Further, the state has charged Laurie Shaver with being an accessory after the fact. You must understand, no individual has any duty to report the commission of a crime simply because they observed a crime having been committed. All right, it's about 11:30 right now. I think at this time we'll take our lunch break. Parties have anything further, state? Yeah, come on up, please.
So we're going to do lunch before we're doing closing. So we are going to go late today because they will stay late. Couldn't closing just be, you heard her, find her guilty, see ya.
Instructions that I will read to you prior to breaking for lunch. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation and the information through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whether the words reasonable doubt are used, you must consider Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? 7, has the witness been convicted of a felony or a misdemeanor involving dishonesty or false statement? 8, does the witness have a general reputation for dishonesty or truthfulness? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that their testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give their opinion. However, an expert's opinion is reliable only when given on a subject about which you believe them to be an expert. Like other witnesses, you may believe or disbelieve all or part of an expert's testimony. You have heard the testimony of a child. No witness is disqualified just because of age. There is no precise age that determines whether a witness may testify. The critical consideration is not the witness's age, but whether the witness understands the difference between what is true and what is not true, and understands the duty to tell the truth. The defendant in this case has
97% guilty.
become a witness. You should apply the same rules to consideration of her testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Defendant's statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to: 1, whether when the defendant made the statement, she had been threatened in order to get her to make it, and 2, whether anyone had promised her anything in order to get her to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. All right, and was that to the satisfaction of the parties?
Yes, Judge.
Okay. And at this time, is there anything further before we break for lunch?
Nothing from the defense, Judge. No,
Thank you. All right, we're going to break for lunch at this time. Again, please do not discuss the case with anyone, including each other. I would ask the parties to return to the jury assembly room at 12:45. So that'll give you over an hour for lunch.
We will be back
Thank you.
at around 1. Is it going to work today, or do we have to do the other thing again today? No, I need to do this. Do this. Do that. Do this. And then do that. No, come on. Do this. Do that. And let's check it out. Come on, work today. Come on. Nope. Ain't working again today. I don't know what's wrong with it. Well, luckily for me, I already have a stream set up to go at 1 because I'm a smart cookie. So I'm going to send all y'all over there. I think I have it up for 1 o'clock. It says Laurie Shaver Verdict Watch because I thought we had been done by now. I didn't expect so many rebuttal witnesses. But we'll be back at 1. Jamie hopefully have stopped sleeping and want to join us. We're going to do the closing arguments. When they go into all the yaga they still need to do with the witness instructions, we're going to yeet it, and then we are going to look at the Carly Gregg hearings that has been the last couple of days and talk a little bit about that, get it ready for next week. And of course, we will have our poll on how long do we believe it'll take to get a verdict. The last time, I think we hit it pretty well, like between 4 and 6 hours. So let's see if we can do that again today. We have had a lot of smart juries lately. Hope this one too. Yeah. Hold on. We always do that around the closing arguments. I have my little things. Hey, Jamie, awake yet? Take out your paper and your trash. Yaggity yak. Don't talk back. Exactly. I'm annoyed that words on stream doesn't work anymore. I liked having that. But now I'll have to just remind you all.
I'm Jimmy. How y'all doing?